This hearing is in the matter of case number CA012-2022 before Chief Justice Zaki Azmi, Justice Robert French, Justice Sir Peter Gross. The appellant is represented by Taylor Wessing, LLP, Dubai Branch. Lead counsel is Mr. Orlando Fraser, KC. The respondent is represented by Tamimi & Company. Lead counsel is Mr. Tom Montague Smith, KC.
Orlando Fraser, Mr. Orlando Fraser. Mr. Orlando Fraser. I think it's the first time you're appearing.
It's the first time I've appeared before you, my lord.
Yes, Mr. Fraser.
My lord, before I begin our appeal, can I just clarify a matter on timings?
Yes.
As we understand, and we're grateful that we are able to sit until 5 o'clock Dubai time. Are you happy with that?
Well, it's 5 p.m. in Malaysia and 5 p.m. in Perth now, and we are ready to sleep until 9 p.m. tonight. So I think Dubai should not be an issue.
Okay.
Shala, did you hear that?
So,
Yes, Chief Justice, not an issue at all.
In any event, we have 4 hours, as I understand it, today. Would you be happy, therefore, for us to have, in terms of breaks, to have a short break after, say, 2 hours?
As a break, I need to do my evening prayers anytime between 2.5 hours.
Yeah.
Yes, fine. Chief Justice, just before break, I think we've reached the position that we're going to have a break after 2.5 hours for your prayers, say 15 minutes. Would that be sufficient? And then on that basis, my learned friend and I have agreed to share the balance of the time of the 4 hours today, subject to the break, and again tomorrow between us. I would aim to speak at about 4:15, 4 Dubai time, and my learned friend will speak again until a similar time tomorrow. And then I will have about half an hour, 45 minutes for a reply.
Are we starting at 4? Shala, tomorrow we're going to start at 1 p.m. Dubai time as well, isn't it?
Yes, same time as today.
Yeah. Okay, that's fine with me.
Thank you very much.
Mr. Please continue.
Now, as your lordships will know from the papers, this is an appeal from an immediate judgment given by Justice Sir Jeremy Cook on the 9th of May last year in respect of the respondent's claim under syndicated facility agreements for payment of around UAE dirham 1.9 billion. This appeal is brought with permission of yourself as Chief Justice, my Lord, by order of the 27th September last year, which is a B45. Now, I'm going to go through our grounds in more detail shortly, but I want to summarise our main complaint about the judgment as follows. We say the main error the judge made was in trying to determine on the documents a major factual dispute about what was said at a key meeting between the relevant protagonists on the 16th of December 2018 at the chairman's villa on the Dubai Palm. The meeting referred to in the documents as the OBN meeting or the Palm meeting. To do so, we say, the judge was forced into conducting just the sort of mini-trial that the authorities, notably the Court of Appeal and Hexagon in this jurisdiction, have held is not appropriate at this stage. The judge's exercise involved a detailed and prolonged consideration of evidence of events over an 18-month period, including documents and witness statements, and detailed submissions by my learned friend and myself on that evidence. The judge, did this in order to ascertain whether or not the appellants had a real prospect of showing that they had been promised more working capital at that meeting in exchange for handing over more security for their borrowing. All of this, the judge...
The prior question, sorry to interrupt, Mr. Fraser, but the prior question affecting the significance of what was said at the meeting must be the question of agency/vicarious liability, mustn't it?
It is a question, but it comes out of the facts, and I'm going to address the facts in the round, deal with ground 6 first, and then go on to agency, and then go on to affirmation.
That doesn't come out of what was said at the meeting, does it? The question of agency.
Well, it's affected by what is said at the meeting, in terms of if we're right about what was said. He was making promises on behalf of. He said Mr. Kazimali's evidence, the North Bank officials, if they were saying things on, well, we can promise you this on behalf of the syndicate bank, it's part of the factual matrix. So
the anterior question is whether there was an agency relationship which would give significance.
yes, and I will, of course, my lord, and I will obviously pick that up as we go through.
Yeah. Okay.
All of this exercise, we say, he did without any disclosure having been given and without any cross-examination of the witnesses to test their written evidence. At the end of this exercise, he concluded, with some acknowledged hesitation, that there was no realistic prospect of the appellants showing that any such promises or statements had been made at that meeting, and hence my clients had no defence to the claims. It is important to stress here that the judge himself had doubts about his findings. Hence, he acknowledged his hesitation in so finding. We say, and this is ground 6 of our appeal, that the judge could not safely come to such a conclusion on a mini-trial where the issue was not clear, without disclosure, and above all, without the cross-examination of the two main witnesses at the December the 16th meeting, Kazimali for the 8th respondent and the chairman. This is the ground which caused the judge hesitation and clearly gave the Chief Justice most concern in granting permission to appeal. And we say that they were both right to have such concerns. This incorrect finding by the judge appears to have coloured his whole approach to the appellant's case. In this respect, our appeal notice highlights a quantity of other mistakes in the judgment, especially his certainty on a number of mixed law fact issues, which we submit lack sufficient clarity for immediate judgment. Taking those mistakes together, your lordships could be forgiven for forming the impression that the judge was coming to the rest of his decisions informed by his negative finding about the appellant's case on the 16th of December meeting. In the end, we say that this is a very high value Durham case against a substantial UAE business chaired by a distinguished UAE businessman. It is a case which bristles with complicated factual and legal points. It was quite unsuited to immediate judgment, but instead requires a substantial trial to get to the bottom of what happened in due course after proper disclosure has happened and witnesses have been cross-examined in light of that disclosure. Going forward to the structure of my submissions, I alluded to his lordship. First, we'll cover some of the evidential background to this appeal, and in so doing, we'll address ground 6 in particular in some detail, intended to show that the judge was wrong in his approach to what happened on the 16th of December. Second, we will then move on to grounds of appeal 1 to 5, which concern the legal consequences of the alleged statements made at that meeting. And finally, we'll go to ground 7 and the freestanding appeal ground based on Islamic law issues. Given the limited time available this afternoon, I shall assume, unless I hear otherwise, that your lordship's pre-reading means that you are familiar with much of the essential facts and law involved in this appeal. Secondly, however good they are, and I say they are, I will not sadly be able to make all the points covered in our written skeleton, and insofar as I do not, your lordships are asked to take them from our written arguments. And finally, I will reserve my reply points until tomorrow afternoon after I heard how my learned friend has made his case. The essential background and ground 6, and we cover ground 6 in paragraphs 93 to 100 of our skeleton, which is at pages A35 to A37 of the bundle.
Mr. Fraser, you're relying on the submission that you put in for the permission to appeal.
Yes, indeed, that's correct.
Right.
That's in bundle A, and it starts at page 8, and I'm going to ask your lordship to turn to page A35 to have that in front of you as I go through ground 6.
A35. Okay.
Starting at 9, ground 6, that heading, the judge was wrong to find that there was no real prospect of the defendants succeeding on their case and the facts of the meeting. Your lordships would have that in front of you. Now, before I turn...
Sorry, did you say paragraph 90?
No, I said paragraph 90, beginning at 93.
93, okay.
Going forward to 100.
I'm using this number that appears at the top of the papers is master A35.
Yes,
that where you're...
yes, so it begins page A35.
J35. Okay, J35.
No, A
Okay.
35. And goes on
Yeah.
to A
Yes,
30.
paragraph 90.
93 onwards. Do you see
Right.
there? It says ground 6. So that's what the ground will be covering now. Now, before I turn to some of the evidence important to this appeal, in particular ground 6, I want to frame this exercise by asking your lordship to consider what happened at the appeal hearing, what he decided in relation to ground 6, and why we say that that is wrong. In particular, at the hearing, your lordships will know that the chairman had put in a witness statement to the effect that at the December the 16th meeting, Bank representatives had promised, in exchange for obtaining the OBN security, which was the last material unencumbered group asset, that they would arrange the supply of more working capital to his indebted group, either through the syndicate or by themselves. And his witness statement, you'll just turn that up, is at D1181.
E1181, yes.
D for Dominic, 1181.
Yes. 118.
Going forward to D1182, picking it up. He starts, sorry, D1180, paragraph 35, just with the heading, the OBN meeting. I want to pick it up on 1181 at paragraph 40. It is also untrue that working capital was not discussed. The discussion was, and at the last hearing, the word "not" was inserted by the chairman overnight on instructions. The discussion was not solely about Bank's exposure. And he then covers his version of events in paragraph 40 and 41. And over the page at 42, the key working capital statements are made. We say that Bank stated, paragraph 42, that they would arrange for 350 million of working capital if we provided the syndicate security over ABN.
In short, you are saying that there might be a dispute of facts.
Yes.
And therefore, they should go for trial.
That's it. That's exactly. And I'm just setting out his version of events at 42 and 43. And he then said, even if the 450 million was not arranged, that's Bank guaranteed provide 100 million in working capital by March 2000 at the latest. It's important to emphasize this was not something they stated they would merely consider, but something they said would do. So that's the chairman's evidence. Turning to Mr. Kazim Ali's evidence, the lordship would pick it up in the bundle at D54, page D for Dominic 54. It starts at D53, paragraph 56, headed 16th of December 2018, meeting at the Palm. And the passage I want to take your lordships to in particular is paragraph 64 over the page on D54, where Kazim Ali says, there was never any discussion about working capital. As far as I was aware, the BBIH group was in discussion with other lenders who had provided existing working capital facilities about that. None of the attendees said anything about Bank providing working capital. Now, full stop, no discussion of working capital. Now, at the immediate judgment hearing, the claimant's counsel, Mr. Montague-Smith, took the judge through the evidence surrounding the meeting, going back 8 months to April 2018, and forward 12 months to December 2019, to persuade the judge that he could accept Mr. Ali's evidence and reject the chair's evidence without cross-examination. And although I made detailed submissions on the same evidence to the opposite effect, the judge in the end acceded to those submissions by Mr. Montague-Smith. And I therefore could ask your lordships to go to the judgment itself, which is paragraph 56 of the judgment, page B for Boris 25. Starting at paragraph 56 under the heading, the 16th of December 2018 meeting. Beginning of I have also come to the conclusion after, are you there, Chief Justice?
Yes, yes.
I have also come to the conclusion, after some hesitation, that notwithstanding the chairman's witness statement and the warnings contained in the authorities about conducting a mini-trial, I cannot accept at face value what the chairman says about the meeting because it is wholly inconsistent with all the contemporary documents. I do not accept that the evidence of Mr. Ali is implausible. And he goes on to say, having decided that Mr. Ali's version of events is plausible, whereas the history of events, he says, prior to and after the meeting meant that the chairman's evidence lacked all credibility. He then goes on in 58 and 64, paragraphs 58 over the page. He covers then the evidence is that in early 2018, the BBH group approached Nor about the possibility of obtaining substantial finance. And he covers from there until paragraph 64 the events, the narrative events and documents from April 2018, which he believed supported his finding that no working capital would have been discussed at the meeting because working capital was by then a matter which the chairman was discussing with other lenders. At paragraph 65, he then discusses the chairman's evidence and he records a number of adverse points about the chairman's credibility concerning his recollections of the meeting. For example, as you'll see in 65.1, he doesn't identify the individual that made any of the statements on behalf. We call that the vagueness point, and other points. Finally, at paragraph 66 to 71, he detailed how the absence of any mention of the working capital promise after the 16th December meeting in the documents was fatal to the chairman's plausibility, leading finally to his conclusion at the end of 72 that the defendants therefore had no real prospect of establishing their case in regard of December the 16th meeting. Now, with utmost and total respect for the distinguished judge, we say that on this occasion his approach and findings strayed into error. And he was therefore wrong to find that there was no real prospect of succeeding in proving at trial that the chairman was telling the truth and Mr. Ali was not. As we say in paragraphs 96 and 97 of our skeleton, A36 to 7, the judge's detailed examination of the documentation and witness evidence was not the sort of surface level review permitted by the authorities to ascertain a credible case or not. Rather, it was exactly the sort of unfair mini-trial conducted without disclosure or cross-examination that the Court of Appeal in Hexagon says is not permitted in cases of such deep disputes of fact. Your Lordships know well the authorities on the mini-trial point, Swain and Hellman, Easier and Opal in the United Kingdom, and Hexagon in this court, all of which are in the parties' authorities bundles and are referred to correctly in paragraph 11 of the judgment, so I won't take up time by going to them.
How do we analyse the judge's approach against the test enunciated, which I think was common ground, at paragraph 11 of the judgment? The burden lies on the claimants to show that the defendants have no realistic as opposed to fanciful prospects. Now, that would be a burden of persuasion, I suppose, which depends upon A, evidence, and B, argument, which would go to, for example, inherent implausibility in the on the part of the defendant's evidence, but it can't slide into a requirement that the defendants show that they have a case, can it?
No, exactly that, my lord.
Yeah, I'm just wanting to trace through the framework, if you like, of his honest reasoning against that test.
Yes, exactly. So the onus is on the claimants and not on us. That I think is clear. I don't think there's anything wrong in that judgment in that. Now, we say the inability of this mini-trial approach to do justice in this case can be seen from a number of doubtful findings made by the judge in this section of his judgment concerning events both prior to and after the meeting, and his findings on the chairman's credibility as a witness of truth as opposed to plausibility of Mr. Ali's evidence. Indeed, as we turn to some of the evidence the judge considered, I want your lordship to consider especially an argument about the implausibility of Mr. Ali's evidence that I made to the judge below without success. Namely, how likely was it that the chairman would not have raised at the meeting the subject of the provision of further working capital from the syndicate in exchange for handing over his last material unencumbered asset, given the long history of the appellant's request for additional working capital from the syndicate banks throughout 2018, and indeed after the meeting throughout 2019, we say submit 0% likely, which means that, contrary to the judge's findings, there must be a real prospect that Kazim Ali's evidence that working capital was not raised at all when they met was implausible, which itself leads to implications as to the reliability of his evidence in general and bolsters the chair's credibility. We say that this made it really impossible for the judge to proceed as he did on the basis that Kazim Ali's evidence about the meeting was completely plausible and the chair's completely incredible.
Mr. Fraser, forgive me.
My lord.
What's the answer to the judge's point about the lack of any contemporaneous documentary reference to this?
Yes, I'm going to come on to that.
You're going to come on. Okay, fine.
It's part of the narrative, and I will come back to that, and I have that very much in mind.
Thank you.
Can I pick it up with the chairman's, the evidence with the chairman's witness statement at the beginning of the narrative? And it's back in the D for Dominic bundles, D1178.
Go, Bobby, I can't give you a scratch on the belly. Please, I can't give you a scratch on the belly.
And we're back at the chairman's witness statement. It's just these paragraphs 22, 23, and 26. Your lordships remind yourselves of those. And this sets the background, the framework of the negotiation, which is that, as said here, Mr. Vig, who is his chief financial officer, proposed that the appellants restructure its debts and obtain working capital through a syndicated loan for 2.1 billion. And it goes on to why it was simpler to have a refinance in this way. The chairman's evidence at 23 was this was attractive to me and I authorized him to explore it. It's important to note here that the appeal of the syndication was also in significant part of the prospect of further working capital funding. The BBIH group needed working capital in order to maintain its businesses and grow. I did not simply want to give the banks additional security in their existing loans and get nothing in return. And then at 26, his evidence is that Nor came to them after their contact. Nor was attractive and said that they were confident of being able to put together the 2 billion syndicate, which included provision for working capital. So that is the background narrative, not undermined by any document nor tested by cross-examination. The lordships will then go back to D73. This is the 3rd of May, taking it a little further. This is an email from Mr. Vig, that CFO for the appellants, to Norbank, D73. Further to the dear Adnan Nakfi, who are both members of the syndicate team at Norbank, syndication team. Further to discussions, I have shared a detailed information memorandum along with the indicative term sheet, financial model for the proposed club deal of DH 2 billion, including the working capital facilities of 300 million for advanced facility management. We intend to create a future-ready company which we can help execute group's vision to retain its leadership position in facility management space. And that information management he refers to is not in the evidence, but is summarised in paragraph 20 of our pleading at C27. And what it underlines is that the proposed facility was for 300 million working capital, as well as 1.7 billion to refinance existing lending. So as it says there in the email. Now, this scenario of a 2 billion facility, including 300 million of working capital, continues to be seen in the documents. I won't go them to, but references are through 2018. References are D for Dominic 107, D159, D174. These are all Norbank internal documents evidencing the 300 million was what was being sought. All the way up until, without any documented reason why, on the 1st of August, the lead arranger appointment letters, your lordships will know about, at D186, that we could go to now, have reduced the facility, have taken out the 300 million working capital, because as you will see there, the facility is for up to 1.75 billion syndicated Islamic finance facility, the facility. So it's 1.75, not 2 billion. So by the 1st of August, this letter is dated the 1st of August, despite the appellant's long-standing requirement for 300 million on top of the 1.7, the appellants have appointed Norbank as the lead arranger to seek only 1.75 billion as part of the syndicated loan and no working capital facility. No record of any reasons for decision making, no register or register of disquiet by the appellant. Now, while Kazim Ali, at paragraph 25, that's at D47 of the bundle, states that this was because the chairman was to have to go to other lenders for this facility in a separate exercise. We submit, as we did before in paragraph 22 of our skeleton below, D1314, it must, contrary to Mr. Ali's evidence, be a possible inference, especially from documents I will come to, that Norbank and the appellants were discussing instead the supply of working capital by all or some of the syndicated banks outside of the formal syndication. And if so, if that is right, that this unrecorded change in the syndicated loan, term loan facility, acts as an indication that discussions about working capital arrangements on the side were had in meetings between Norbank and the appellants, which did not make it into the documents. i.e. not everything is in these documents, which of course has some significance when considering the chairman's prospects of establishing an undocumented oral agreement later on in December. Just on this letter, on this point, I'll come back to this letter in respect of agency and other points, but please note in paragraph 5.1 at D188, the clear market clause. And that was to the effect that the appellants had to get Norbank's written consent on having appointed them, had to get their written consent to raise any working capital or other funds other than from the syndicated banks going forward. So Norbank would have to have been informed had the chairman been trying to do this, and there's no evidence at all that the chairman was trying or that they were so informed. So in other words, this clause is additional evidence that all of the chairman's eggs in the syndicated bank were in the syndicated bank's basket throughout this period, to the knowledge of Norbank. Certainly, the fact that 1.75 billion did not seem to be an end to the working capital issue from the appellant side may be seen from the next exchange. And I ask your lordship to go forward in the D bundle to page 413. At D413, so this is from the appellant Misbah Ejaz to Mirza Ali at Norbank. Dear Mirza, it was a pleasure meeting you and the team last week. So there was this is the 9th, the 2nd of September. So there was a meeting in the previous week at the end of August. It was a pleasure meeting you and the team last week. Agreed, we are waiting a final term sheet from your end, please, at supply. And at page 415, you will see the response from Mirza Ali. Dear Misbah, that's Mr. Ejaz again, reference to our ongoing discussions on the subject, please find attached the draft term sheet for your review and feedback. That term sheet, which is at 418, and that reflects more or less the 1st of August letter. The first one of 1.75 billion. Your lordships will see that of indicative term sheet up to 1.75 billion Sharia compliant. So that reflects the amended in the term sheet. However, the appellants respond by a 6th of September email from Misbah Ejaz at 429. And at 429, first I'm going to go, it says, Dear Mirza, from Misbah Ejaz, please, dated the 6th of September. Please find enclosed amended term sheet for your review. And just going to the amended term sheet before coming back to the email, that is at 433. And there you will see that the term sheet is now being amended to 1.7 billion term loan and 300 million working capital facilities and 200 million bank guarantee limits. Going over the page at 434, where it describes facility, it describes there are 3 facilities now Facility 1 up to 300 million working capital limit, Facility 2 up to 200 million bank guarantee limit, and Facility 3 up to 1.7 billion syndicated term finance facility. And going just where they describe Facility 1 working capital, participation of financial institutions in the working capital lines will be in proportion to their participation in the facility. So that's how it's envisaged. Going back then to his covering email that we originally looked at 429, as discussed in our meeting, under the, it says, please find enclosed meditation for the audience. As discussed in our meetings, in that meeting, in addition to the 300 million working capital lines, we are requiring 200 million bank guarantee limit, current exposures around 120 contract assignments. I would suggest that is, he is suggesting that the working capital and guarantee limits come into the facility. It's indicated by suggestion by him at this stage it wasn't agreed in the meeting, but the limits have been discussed. And further, and this is really important, I would endorse your suggestion that participation in working capital lines from banks should be in proportion to their respective exposure in the term loan facility. So far from it, so it does appear that Norbank had been proposing that extra working capital would indeed come for the appellants from the syndication banks in proportion to their syndicate loan participation, but just not in the syndicated loan. Your suggestion. So presumably the Norbank had been saying yes to the working capital 300 million, but just outside of the syndicated loan. And that obviously backs up what we're saying about these limits being agreed outside of the formal letters. So it supports, we say, our theory that the lead arranger letter reduction to 1.7 billion did not reflect the appellants having to get working capital from other lenders in a separate exercise, contrary to Mr. Kazim Ali's evidence, and also that the Norbank were having meetings and making oral promises about working capital on the side from the syndicated banks throughout this period. Did not make it into the official documents. Now, I'll come to their response. On the 9th of September, ostensibly it rebuts this, page D50.
Sorry, D what?
450. Apologies, Michael.
Yeah.
Now, he says there, hi, Misbah, the discussion we have had earlier was for 1.7 billion syndicate, mainly for term exposure, while understanding that the working capital limits would be continued by existing banks or arranged by you on bilateral basis. Let us know if further approvals have been reached out. Now, he does not rebut the idea that the 300 million working capital was expected to come from Norbank and the other syndicated banks. He doesn't deny your suggestion point, the pro rata participation. What he's making clear is he's rejecting Misbah Ejaz's attempt to get the working capital into the syndicated loan itself. Hence, we say, looking above, Misbah doesn't protest. Dear Adnan noted, let's close the term of exposure of 1.7 million. If he thought that was it for the 300 million working capital facility from the banks in total, he would have howled, we say, not said, OK, let's draw the line on the syndicated loan at 1.7. There's a definite sense here in our submission that, consistent with the promises we say were made later on in December, Norbank officials were making side promises about the working capital outside the syndicated loan itself, your suggestion. If we are correct here, we would suggest that we are a long way from the picture Mr. Ali paints in his evidence at paragraph 33, saying that the appellants would have to go into the market for this. We just, Lordship, just pick that up at D48. Paragraph 33. Following this exchange, it was made clear to the BBH Group that any syndicated loan would only provide a term facility to refinance the group's existing borrowing. If BBH Group wanted to get working capitals over and above that, it needs to go into the market and obtain those facilities separately. And that's just not consistent, we submit, with what the documents are saying. The next part of the picture is at D501, which is the final term sheet. 501 is a email from Misbah Ejaz from the appellants to Mr. Mirza Ali of the 8th respondents, Norbank. Please find below contact details of bankers as desired. Duly signed term sheet is attached, and that is at 511. And as you see there, the facility has the term loan element has actually increased to 1.85 billion. So some result, it appeared, from Misbah's pressure for more facilities. Now, no working capital facilities in here, and your lordship can see that at D5112. It's only the term loan amount. But now, the first time, we see that the agreed term sheet has a provision whereby the appellant's covenants not to raise more than 500 million working capital outside the facility at D51, and that's at D517, financial covenants, covenant number D, working capital finance not to exceed 500 million. Must be outside, it's not within the term loan. Now, that's not in the term sheet before, and effectively gave the appellants carte blanche to raise sums outside the syndicated loan. So it's a permissive, consistent both with getting such sums from the participant banks, including Norbank, outside the syndicated loan, as we suggest was on the cards, as with going to the market, of which there was no evidence. Importantly, this point is inconsistent with the finding the judge makes in his judgment that I shall come to, and which we complain about. In this respect, shortly after, on the 30th September at D554, Misbah Ejaz sent an email underlying the continuing importance of NOR arranging working capital to the appellants as part of the syndicated loan process. In this respect, he is responding to a 30th September email from Adnan Khan, which he sends forth cash flows and projections, saying, "Dear Adnan, kindly also update us regarding working capital facility mechanism. It's a must, otherwise the whole syndicated effort will go useless." We say that statement, at the very least, supports the case that Misbah and the appellants have been told by NOR that they will arrange an extra working capital facility on the side, and consistent with the chairman's witness evidence, that the working capital is central to the syndication, whether formally part of the syndicated loan or not. Now, true it is, importantly, Adnan Khan responds immediately above, not by saying, "I don't know what you're talking about." What he says is, "Let's have that sorted tomorrow." Now, the implication that acknowledged that Norbank would sort it out, as it seems they had promised the appellants something. Now, there is, we say, a real prospect that Norbank did provide further comfort about a working capital facility as the syndicated loan process continued, and Misbah Ejaz had said the syndication effort would be useless without a working capital facility mechanism, so something was given. And if we go forward, we see evidence of what the sort of promises were, more specific evidence. If we go to 557, which is the 2nd of October, from Adnan Khan, the 2nd of October, the middle of the page, from Adnan Khan to Misbah, appellants. "Dear Misbah, I hope this finds you well. We were earlier provided with attached two files showing the borrowing exposure of AFM Syndicate Group. And you can see he forwards those two files as two attachments above to internally within Norbank. One's called Syndication Bank Borrowing, and one's called Bank Borrowing Settlement Plan. And what we then look at those documents. The first document, which appeared to be the bank borrowing, is at 559 to 560. Is dated the 18th of September, so exactly around this time, the time of the final term sheet. And we see the bank borrowing, it's borrowing at 1.983. And behind that, there is a table of future banking partners. And what we see here that would seem to set out the plan for how the appellants would get 450 million of extra working capital and guarantees from the syndicated banks, because you see the syndicated loan on the left and the participants 1.8 billion. The next column is working capital, that's 300 million. And then that adds up to 2.1 billion. And then you have bank guarantees of another 150. And on the face of it, at that time, it seems to be a plan. And you'll see there that Norbank is in for exactly 100 million. And you note the 150 million of bank guarantees on top of it. And on the face of it, we say that this is maybe an indication that the appellants have been promised the syndicated banks would be a source for the up to 500 million figure we've seen outside working capital in the 19th September term sheet covenants. And as you can see, it's pro-rated amongst syndicated banks, the working capital, per Mr. Adnan Khan's previous suggestion, or your suggestion. So looking at this document, at that time, Mr. Ali's own witness statement at paragraph 35 does look, again, highly questionable, and that's at D48. On the 16th September, MISBA responded with further amendments to the draft, this is paragraph 35, term sheet in relation to security operation collection of the amount. So this is what's at that time. There was no mention of a working capital facility, and I believe at this point, the BBRX group had understood the proposed syndicate would not be providing working capital, and that appeared to be quite inconsistent with the document we've seen at D560. Now, the judge, at paragraph 62 of his judgment, and we see this at B27, B for borrowers 27, paragraph 62, he dismissed the significance of the email of this exchange I've just taken your lordships to with considerable certainty. His summary finding was this exchange related to another issue, namely settling a dispute over the amount of working capital that the appellants was to be permitted to raise from other banks outside the syndication. When Seeding contacts, he says, this has nothing whatever to do with the provision of working capital by Nor as part of the syndicated loan. What it relates to is the debate about what total sums the group were to be admitted by the covenants and the finance documents to raise by way of working capital outside the syndicated loan. Different limits have been discussed, notable, including figures of 500 million and 350 million. And he says, by this stage, it was abundantly clear from the term sheet and the exchanges that there was no working capital within the syndicated loan. Now, we say on this point that the judge's certainty is quite surprising. The words themselves could be more obviously be suggesting that the appellants wish to firm up on your suggestion plan showed in the table at 568. Please confirm arrangements on how we're going to get more working capital out of the syndication banks outside of the syndicated facility agreements. Otherwise, the whole syndication is going to be useless. So we say it's more consistent with working capital actually being provided. The judge reached his own contrary conclusion without the benefit of disclosure or cross-examination of witness statements. Indeed, he even reached this conclusion without the benefit of any witness statement in support of his own conclusion, if you like. So there was no supportive witness statement at all. There was no witness statement evidence as to the meaning before him either of the two relevant emails between the two of them, between Adnan Khan and Misbah Ejaz. The only evidence was from Mr. Ali for the claimants, and he was not able to be so confident as the judge, as he said he did not know what was meant by the phrase, let's get that sorted tomorrow. That's at paragraph 31 of Ali at D49. I don't know, he says. So Mr. Ali says he doesn't know what is meant by that, how can the judge be so certain that he does know? Indeed, if you think about it, why would Misbah Ajaz mean what the judge thought was so obvious if, as we have seen, permission for the working capital outside the group at up to 500 million had already been agreed in the term sheet? Just then. There's no evidence about any dispute about this. All that this term of this amount was changed to help sort the appellants after the 2nd of October. It wasn't decreased at all, this sum, after the 2nd of October, but in fact ended up many months later in the agreements at 350 million, or much less. So it doesn't seem to fit the judge's theory. It doesn't seem that the judge's theory fits, at least not on a summary basis. Much more likely, we say, that when Misbah Ajaz said, kindly also update us regarding working capital facility mechanism, it's a must, otherwise the whole syndicate effort will go useless. Much more likely, we say, that they were actually seeking to nail down the extra working capital funds from Norbank and all the other banks as part or aside the agreements. We submit that the judge's certain conclusions here were not open to him on a summary basis, which must leave it open as a real prospect that the appellants and Norbank still working on the premise that Nor Group and the other banks would supply substantial working capital on the side of the agreements, just as we say they promised again on the 16th of December. So it does give more plausibility, we say, to the chair's count of events on the 16th of December. Now, the other point to make in relation to the judge's finding is that even if the judge was right and the exchange only referred to the appellant's anxieties to be free to raise working capital elsewhere, that would not dramatically reduce its significance as part of the backdrop of the 16th of December meeting. In other words, the document still shows the appellants being concerned in being able to procure working capital to keep going, which therefore makes it more likely that when Norbank demanded the extra OBN security on the 16th of December, as they admit they do, the appellants would have asked for a working capital commitment in return. The judge didn't mention this here, but just regarded his conclusion on the email as solely corroborative of Mr. Ali's evidence. Now, moving forward on this issue, we then have to consider the chairman's witness statement evidence about the meeting, key parts of which the judge rejected, as we say, and although the chairman was at a previous blemish as a witness of truth. His evidence begins in page D1179, D for Dominic 1179. I've shown you, your lordships, a bit of it already this morning. Paragraph 28. Beginning, however, as matters progressed, it became apparent that Norbank's syndication was not living up to its promises. And he talks about how they'd mishandled, going forward, 28, 29, 30, 32, 33, and 34. Remind yourselves of it again. I'll make my submissions as I do so. There's evidence there is, and this is not rejected by the judge, so it's an important factual matrix. Norbank had mishandled the syndication such that it's taken longer than it should, and it's as smaller than it should be, which has resulted in additional pressures on the appellant group, with loans expiring, default possible, bringing down the whole group. To address these additional pressures, the chairman needed to raise funds using the extra unencumbered security of OBN Energy, important financially to the group, worth 500 million or so, and of some sentimental value. And you see that, paragraph 31. I needed as several of the group's credit banks would say would not be joining the syndication, I needed a plan to deal with these bilateral loans and raise funds for operations. In this regard, I was considering raising finance against OBM Energy. When in December, NOR itself demands, which is paragraph 33, that NOR demands that they are provided with the OBN security just to enable the below par syndicated loan to proceed. The chairman is angry, he's not grateful when he's told this by Mr. Vig, and makes it clear that prior to the meeting, he will want further working capital, provided or arranged by NOR if he is to agree to give up this important collateral. Otherwise, the group simply could not survive. That is why he flew back for this meeting. So, going into the 16th of December meeting, based on the unchallenged evidence before your lordship, we submit the appellants have at very least a real prospect of showing that the chairman intended to demand such extra working capital in exchange for offering up the ABN additional security. Now, it is also worth noting that this meeting itself took place in the very dog days, the very final stages of the completion of the syndication. And you see that from D1208. Which is an email from Norbank into the portal which they were running for everyone, to the syndicated bank, setting out the final stages. It's dated the 13th of December 2008, from Mohammed Ashfaq Shafi, Norbank. It goes into the undisclosed recipients of the under-syndicated banks. And as you'll see there, please find below the timeline agreed with the company. And it's a very shortened timeline between the 13th of December, setting out 7 or 8 steps, ending with the signing of the facility agreements on the 20th of December. So everything's been now done in a rush. Now, as to what happened in the meeting, we go forward in the chair's witness statement at D1180. Now, much of what he says, and this is at 35 to 48, and we've seen some of this already, much of what he says is agreed by the respondents. They accept that a meeting happened. They accept that it was caused by Norbank's demand for the ABM as extra security. And they now accept, although they previously didn't in their pleading, they now accept that Nor threatened not to participate in the syndicate if the appellants did not supply the extra security. Their original denial is in their reply, paragraph 45 at page 681. There's no need to go for it now. The dispute, in effect, is over paragraphs 40 to 43 of the chairman's evidence about the Norbank's working capital promises there and Mr. Ali's denials. Now, as I say, the dispute is limited to a clash of recollections between the chair and Mr. Ali. There are no other witness statements corroborating the evidence of either witness before this court or before the judge. No audio or video recordings or formal minutes of the meeting. Significantly, the respondents have not put in witness statements for any of the other 3 Norbank attendees, Adnan Khan, Faisal Sheikh, or Mohammed Naqvi, corroborating Kazim Ali's witness statement. On the face of it, we say this is a classic factual dispute of recollection that cannot normally be resolved summarily on the papers, but instead would require cross-examination of witnesses for a judge to be satisfied that he could come to a view one way or another about the credibility. Such cross-examination would also be assisted, of course, by full disclosure from Norbank of internal emails or documents which post-date the meeting, and thus would enable the court to see contemporaneous internal documents evidencing what Norbank considered was said and or agreed at the meeting. Accordingly, we say that the judge was wrong to think he could cut through all of this and decide Mr. Ali was telling the truth and the channel was not on a summary basis. It's far more likely from what we've seen in the documents leading up to the meeting that Kazim Ali was lying and the chairman was not. And about the question of whether working capital was being raised, and if he was lying about that, that leads to the question about there is a real prospect that he wanted to cover up the fact that the subject was raised, that promises were made to get the security out of it. It's whatever else it is, it's not clear the other way around, what we would say. And also, looking at the paragraphs 42 to 43, let's not forget the source of some of the key figures mentioned in the chairman's evidence have some documentary backing, as we've seen. The 100 million promise that we've seen can be traced back, arguably, to the mid-September schedule I showed you at D560. The 350 million promise that he says, when at 42, Norbank stated they would arrange for 350 million working capital to be advanced by the syndicate after the syndicate was closed, could well represent the amount of working capital that they were permitted to raise, because by that point, that figure in the documents is now precisely 350 million, and that's clause 19.5 of the syndicated facility agreements, D874.
Sorry, the Norbank narrative was that they had taken security over the elements of the work camp to support the bridging finance.
Yeah.
And they had to release that to the proposed syndicate, otherwise they wouldn't get up, and that they needed to support their own exposure with the proposed mortgage.
Yeah, exactly that. Now, So what we say, given there is some figures in the documents, it's not wholly incredible that it was discussed and promised in these circumstances. Now, not only do we therefore submit that your lordship could have genuine doubts about the correctness of the findings of Mr. Ali's versions of events was backed up by all the documents prior to the meeting, but we submit that the judge overstated the strength of the other factors he relied on in his judgment. Thus, we go to the negative points in paragraph 65 of his judgment that I showed the lordship at the beginning. And the first one is the chairman's vagueness of recollection when he said who at North said that the working capital statements, his lack of recollection of who precisely it was who said it. Now, in interest of time, I'm going to deal with this quite swiftly, but just point to our skeleton at paragraph 97.3, which is at page A37. On page A37, one of the main facts identified by rejecting the credibility of his vagueness. However, the chairman provides extensive reasons, paragraphs 8 to 20 of his witness statement, for why he is vague on certain matters. And we summarise those there. And what we say to that is those are perfectly good reasons why the chairman would not have been on top of who precisely it was who said what at this meeting amongst a number of Norbank officials. There were 4 of them. And we say the flaw in that approach is to be contrasted with Mr. Ali, because the judge did not, Mr. Ali himself couldn't identify who amongst the Nor said what. And you see that in paragraphs 61, 63 and 67 of his own witness statement. He doesn't know who said what. From Norbank, he can identify the chair, but if you look at Mr. Ali's witness statement, at paragraph 61, at page D54, we explained to Mr. Al-Malheri that Norbank reduced exposure, doesn't say who. Paragraph 63, we mentioned the discussion, doesn't say who. And paragraph 67, I should mention there was also discussion about Mr. Al-Malheri's promise to inject 100 million. He doesn't say who for Norbank. So he is just as vague about who amongst them was speaking, but you don't hear the judge mentioning that. And we say that he shouldn't have concluded a summary hearing that the chair's vagueness should be held against him in the way that he did. Further, we say in paragraph 99 of our skeleton, as regards the judge's part,
forgive me, yes. Is that fair? Mr. Ali is talking about what his colleagues presumably said.
Yeah.
There's no great dispute about that. Whereas on the other hand, the chairman, with respect, is suggesting that something very specific was said about working capital, which is fundamentally in dispute. Isn't it perhaps surprising that he couldn't say, well, it was Mr. X or Mr. Y, or it wasn't Mr. Ali, but it was his colleague, Mr. Z?
My lord makes a fair point. Can I just address it in this way, which is to say that on the one hand, the chair was a very senior businessman on the other side of the person who would not particularly know the individuals. I think that's in his evidence. Secondly, Mr. Ali would know his individuals well, but he doesn't seem to remember. Now, it's a fair point that the discussions that Mr. Ali in his witness statement is talking about are less controversial, perhaps, although not to us. And so I think your point could be made in that respect. But I still think there is a vagueness, Mr. Ali. The chairman's vagueness, we say, is explicable, and there is a vagueness, Mr. Ali, which is not picked up by the judge as well. I think that's as far as I can take it.
Thank you. Can I, while I've interrupted you, ask you one other thing? Yeah. And that is this. Just imagine you made some progress on this issue. That's your ground 6.
Yeah.
On the points you've made about what was open for summary determination and what wasn't. But imagine you made no progress on the agency and other points, ground one and so on. This is just a hypothesis. No conclusions have been reached at all.
Yeah.
Does that leave you with a potential claim against Noor Bank, but not against anyone else?
If that is what's happened.
Yes, imagine this is only hypothetical.
Imagine, I mean, you could say if we made progress on this aspect, your lordship might then say, well, given that we would like to see the trial judge would like to see the factual matrix on this point, that actually they should see the factual matrix on all the points.
Yeah, I know you'd like that, but imagine you didn't quite succeed to that extent. Imagine you succeeded on this point,
yes,
but failed wholly, heaven forfend, on ground one. That leaves you with a potential claim against Noor Bank, but not against the others. Is that right?
I think that's correct. I'll subject to correction from my juniors, but I'm prepared.
Okay, forgive me. I'm just trying to.
No. I think that's actually right. Now, my lord, there is another point the judge made in his adverse findings about our credibility at 65 in paragraph 65, which is the point of 65.3, which we take issue with. And he said there's an inconsistency in his evidence as to whether or not security was to be given to Noor alone or the syndicate, which it does appear on the face of it. The logic of the deal, which he suggests, was to make it should be provided for Noor only, but he says he understood that it was giving them the mortgage, which is indeed his evidence. By this time, giving them their capacity as lead bank of the syndication. And in support of this, Judge says, by this time, however, the draft syndicate documentation shows that the first claimant had taken over the position as lead bank. And that is simply a mistake of fact. I think it's acceptable, my learned friends. There was no draft syndicate documentation before the judge for him to make that finding. So he simply can't rely on that point. So those are two points that we say undermine this aspect of the judge's findings about the chairman. Now, then I want to come on to Peter Grace's point about the absence of documentation. He raised it earlier, and I said I would come to it. Now, the third reason the judge gave for disbelieving the chairman, namely, as you say, what he saw as the complete absence of documentation after the meeting, supporting the fact that any such promises were made by Noor Bank, is, we submit, not as strong as it first appears. It is certainly a good point for cross-examination of the chair at trial, but we submit that it is not strong enough on its own to overwhelm at this stage the evidence we have gone through supporting the chairman's version of events. In this respect, such evidence or absence of evidence is still only indirect evidence of what was said or agreed on December the 16th. It is not direct evidence itself, of which we really only have the chairman's word against Mr. Ali, which dispute needs to be resolved by cross-examination. Whether an enforceable agreement or not was struck at that meeting will depend above all what was said at that meeting and the factual context around it. Evidence of post-meeting communications will be helpful, but not determinative. By way of example alone, you could have a situation where a legally enforceable agreement was arguably struck on day one, but by day 8, the economic situation had changed as to make enforcement of it difficult anyway for one party. It doesn't stop the agreement having been struck, but it might explain why that party is half-hearted in its efforts to obtain compliance from the other. It's difficult to enforce an oral agreement, no leverage to secure enforcement anyway. In the present circumstances, as I have shown you, the potential agreement was stuck in the frantic dog days of the syndicate loan negotiation, when, as the chairman says in paragraph 47 of his witness statement, and as would be explored more at trial, the chairman and the BBI group were under enormous financial pressure. And that's D1183, paragraph 47 from the chairman. To summarize, I was in a very difficult position. The BBI group was under extreme financial pressure. I needed to do what it took to ensure it would survive. The syndication needed to go forward. So they're under enormous financial pressure. It was growing on a day-by-day basis the more the syndicated loan was delayed because of the expiring of the term limits. So while the appellants needed Noor Bank to honour the agreement to provide more working capital in exchange for security, they also desperately needed the syndicated loan to complete. So Noor Bank, which controlled the syndicated loan process, had them over a barrel. In these unequal circumstances, the fact, therefore, that the appellants handed over the OBN security on the 25th of December, which is agreed between the parties, without getting that extra working capital documented, just to get the syndicated loan completed on the 28th of December does not necessarily mean that the relevant legal promise was not made on the 16th of December. It may just mean that the appellants recognised commercial reality and complied with their immediate demands for the bigger picture. Further, once a security has gone over and no working capital received, the appellants have lost any leverage, as the groups are in increasing financial trouble and now relying on the goodwill of the respondents to survive. Hence, as we'll see, the tone of disappointment from the failure of the respondents to supply working capital in the 2019 correspondence and the appellants, rather than demanding compliance with an arguable oral agreement. They wanted more working capital, perhaps, and politeness is the better route. Doesn't mean that the agreement didn't happen. Finally, your lordships have to factor in the many personages on the appellant's side. Plainly, as we see from his evidence, the chairman thought he had an agreement on the 16th of December. On his evidence, he flew in from New York, made the agreement, shook on it, walked off to do other deals, leaving his juniors to implement. They did not implement it, as we have seen. Does that mean it didn't happen? Not necessarily. There may have been many reasons for that lack of implementation, incompetence, lack of belief, decisions to try another tack, whatever, but the legal agreement may still have been struck. All of these possibilities, which could be explored at trial, mean that the importance the judge attacked for the lack of significant mention of the December the 16th oral agreement in the post-meeting communications was overstated and the situation not so clear, rendering impermissible a mini-trial approach. And hence, those are the big picture points on lack of absence of mention. But also, we submit the judge somewhat overstated the clear quality of the post-meeting documentation and failed to appreciate the significance of one key exchange in particular. Thus, in the absence of recordings or minutes, as we know, the judge placed great store in his judgment on emails at D593, 595, 623 and 626 and so forth, passing between Noor and the chairman's staff following the meeting concerning the completion of the syndicated loan and some of the matters discussed at the meeting. But 2 points can be said about those documents. First, they were not intended on their face to be a complete record of what was agreed. That was intended to come in the eventual written agreement, which was promised by Noor Bank but never ultimately executed. You can see that at D626. This is on Christmas Day.
What else would one do on Christmas Day?
Indeed, they confirm the principles. This is Adnan Khan, 626 at the top, confirming the following from their point of view: the principles Gulf share to be pledged to us, and OBN asset will be mortgaged to us and will be released when NOR comes down to 250 million. This has been agreement with you, will be incorporated in a side agreement that my lawyer is drafting. Since she has been busy, she will not provide this earlier. However, it will happen, and that's and we see the security was executed on that day. But no written agreement was in fact ultimately executed. Once they got the security, they had what they needed, and you'll see this from Kazim Ali's own witness statement, which is in D66. Paragraph 120. It just comes to the culmination of he discusses the progress on this agreement, and he goes, in the end, Noor Bank never sent out drafts or executed a formal written agreement in relation to OBN Energy or the Gulf shares. He never did so. The bank never made arrangements for a formal agreement about security. It did not need to do so because it already had the benefit of the mortgage and so had the security it required. So had there been an actual final agreement, that would have been subject to the chair's approval. It's likely to be an important point, and the chair makes that point in witness statement, paragraph 10, D1175. And given his evidence, there must be a real prospect that he at that point would have intervened to include a record of the 100 million promise he believed he had extracted. So it has to go through this process. It's not over yet. Just because these documents don't show a reference, the agreement is still being formalised. The second point about that, it was, of course, during the negotiation of these exact agreements accompanying the ABN security that we see the appellants asking for another 100 million in credit from Norbank as part of the ABN deal, which is what the chairman said he was promised on the 16th of December. So quite strong corroborative evidence of the chair, which the judge referred to, but did not pick up the significance of. And we can see it if we begin at D621. This is from Amit Padya of the appellants to Norbank. Dear Adnan Naqvi, it's dated the 19th. Further to your meeting, we agreed on the following, and it sets out the two agreements. On the first one on the ABN and the second one on Gulfer. And then it says at the bottom, Norbank to share the draft side agreements in line and above for our review. And this is all happening very, very quickly because they're trying to get the syndicated loan over the process at the same time. And if we go forward to Mr. Khan's response at 626, I've already taken the Lordships to on Christmas Day, and he refers to there, we will, one, the Gulf share to be pledged to us, two, OBN asset will be mortgaged to us and will be released when NOR comes down to 250 million hold in the syndicate. This has been our agreement, and we will send you a draft in due course. At 977, at the middle of the page, Adnan Khan, 8th of January. This is the letter we're going to issue today, covering the pledge. Please send to us the original executed pledge documents for Gulfer. So they already have OBN security. We refer, and in the italics is the proposed draft. We refer to the following: the mortgage over plant and the equipment granted by ABN, the ABN security. Please note, we agreed to release the mortgage as soon as reasonably practical after our exposure under facilities is reduced to 250 million. And if we go to the appellant's response, which is above, on the 14th, for a few days later, they thought about it, and that comes to, and please find attached the draft side letter on the OBN mortgage, letting you any comments. And that then is at 979. And you'll see there, their own draft, Mr. Almeida, dear sirs, is proposed to say, as regards the mortgage, the ABN mortgage, NOR agrees to irrevocably, unconditionally release the mortgage as soon as possible after NOR's exposure under Agreement 500 has been reduced to 350 million. In other words, it's reflected a difference between them of an extra 100 million of credit from Norbank to the appellants. Norbank is reducing down only to 350, not 250, which 100 million is, of course, the exact amount the chairman said was promised on the 16th of December. It is, of course, that same 100 million we saw back in the September figures at D560. Now, it's not additional working capital, we accept that on top of everything, but it does arguably show that the appellants considered that they were due 100 million of credit in some form from Norbank in exchange for the OBN security. NOR then went completely quiet on this and did not proceed to agree any such agreement, but rested on the security they had obtained on Christmas Day. And we saw that from Mr. Ali's witness statement, paragraph 120. It raises the spectre that they didn't want to go on the negotiating agreement, they would be held to the 100 million promise. We say all this cries out for investigation at trial. Now, although the judge did refer to this 14th of January Padjar email in paragraph 67 of his judgment, which is at B30, there were exchanges, the paragraph beginning in December and January to NOR group of draft side letters to record these matters. They were never executed. And he refers to the difference. he doesn't pick up the 100 million. He says we don't have an explanation for them. But on due respect, distinguished judge, we did actually. We did suggest that 100 million figure was significant, a significant mention of what had been raised. And he doesn't mention the possible link, or may not have appreciated the significance. So we say an error here. Had he appreciated it, he would have found it difficult to conclude that all the documents in the claimant's favour, and indeed to conclude that we had no real prospect of proving our case on this issue as well. And we made that argument in paragraph 97.2 of our skeleton before your lordships on A37. So so we made those points. And then even the evidence after the 9th of January, we say, after this exchange, is not wholly in the respondent's favour, so as made to declare that no promise was made on the 16th of December. What we see, if we turn to the chairman's witness statement, is oral evidence of complaints by the appellants about the respondent's non-provision of capital or non-compliance with the oral agreement. The first of that is at D1185. Paragraph 52. Whenever I met with the banks, I would complain about the failure to provide working capital. The banks refused to release operational funds from the revenue being routed. Paragraph 53 to 4, talking about a meeting in December, and things all came to a head. And at that meeting, 54, I also at that meeting complained that banks had secured to OBN and hadn't provided me the working capital for it, and that evidence has not been addressed by them or replied to. So not denied that he said that. So those are two bits of evidence that don't go with all the total flow the judge felt. There is also oral evidence here of the respondents promising more working capital in exchange for compliance with the syndicated facility agreement. You see one at paragraph 51, going back a bit, quite early on in March 2019. Paragraph 51 of the chairman's witness statement, D1184. However, to keep us aboard, the banks kept on stringing us along with the promise of working capital. For example, Gail Hanley and the BBA's group, they told me of a meeting that occurred in March 2019, the day before the first instalment payment under the syndication was due. The meeting was held to discuss this. Going further down the page, Mr. Khan, who's of the syndicated bank, stated that if the first instalment was paid in full, the following day he would have Nor Bank on the other side of the table ready to provide working capital, and that didn't happen. Paragraph 52. You'll see another example of this in September 2019, the chairman's evidence. They would use similar capital tactics with me, this is at D1185, middle of 52, as they would with my employees. For example, when the banks came to visit me in Guildford in September 2019, they were insistent that I sign a promissory note, which I exhibit, and it is there. They told me if I signed a note, they would give me anything the appellants needed. However, after they did not follow through. Now, there are also, that's his own evidence. There's also some documentation support, If your lordship would go to D1454. This is the back of the D bundle. It's an email from Misbah Ejaz, who is corresponding with other banks outside of the syndicated loan about working capital. And at this point, fairly desperate march. Dear Zaki and Shoandu, hope you are going well. It refers to our recent telecom. While closing the syndication, we overlooked the working capital requirements of the 70% projects that are assigned to the syndicate. Due to the lack of necessary working capital, our syndication cash flows at the moment are under stress. We're trying to arrange more working capital from the syndication bank, everyone's understanding. And this is, he copies into this, I think it's his boss, Rishi Vig. And Mr. Vig says this is a fact above. This is a factually incorrect statement. We did not overlook the working capital requirement. Our understanding has always been to get working capital after the closure of the syndicate bilaterally. It was a mechanism that needed to be finalised. It was a mechanism that needed to be finalised. Borrowing agreement talks about 350 million working capital lines, and that's the agreement in the syndicated facility agreements, which certainly can't be supported by 30% of the business. In other words, that 350 million permitted limit was anticipated to be coming from the banks, and it's that 350 million figure. And the phrase mechanism to be finalised could embrace the outline promises, the promises made by Norbank at the meeting about from working capital syndication banks. It's certainly internal evidence that the working capital issue was still alive before, at, and after the meeting, which supports our evidence. The judge felt that this did not support our case, but didn't concentrate on the wording. Mechanism that needs to be finalised could embrace a legal agreement that just needed documenting, we say. We also see many documents showing the appellants seeking working capital from the respondents with disappointment that none provided so far. I'll give you some of the references here. D1026, that's the 27th of March mistake letter, and includes requests for 200 million of working capital. There's one DO27 to DO129, 14th of May, 19 minutes, again seeking more working capital. Wanted equity infusion doesn't mean the working promise was not made. And we have the chairman's letter, again, disappointment about the lack of working capital. We could take the lordship to that, D1030. And he goes, 25th of July 2019, dear sirs, I'd like to thank you for your continued support in the existing facilities. As you know, the current economic conditions severely restraining the liquidity of many companies. A recent lack of working capital facilities being extended to our group companies at this crucial time, which has a spiralling impact on the operations of the factories. So we get some support there for ourselves on that point. And it's D1031. This is just next to that is the Project Maris report, which is about the financial commission by the appellants into the financial condition of the appellants. And there is a reference there at 1044, my learned friends rely on, but we think it actually supports our case, or at least makes it unclear, at 1044, background overview. And on the right-hand side, under overview, then under current performance, then under January 19 debt restructuring. In January 19, a syndication deal was finalised with 7 lenders across the group, representing AD 1.7 billion of exposure. Management advised the primary objective of the syndication had been to offer additional security to lenders in order to secure additional working capital facilities, consistent, I say, with the evidence about wanting the working capital being in the background of the meeting. However, while additional security is being granted, no additional working capital was secured. So nothing's actually happened. It doesn't mean it wasn't promised, it just hasn't happened. It hasn't been secured, and that's the disappointment. So we say, although we accept that there are no specific written complaints in the evidence about the respondent's non-compliance, answering your lordship's question, with the December the 16th oral agreement, there's enough other material to reduce the force of that as a negative factor. And of course, the fact that there is so much documentary evidence of the appellants continuing in 2019 to demand working capital from respondents as they had throughout 2018 undermines yet further Kazim Ali's denials that the working capital would have been discussed at all on the 16th of December when they asked him for their last incumbent security. Further points we should make about the absence of significant quantities of documentary evidence supporting the chairman's version are mitigation factors set out in the chairman's witness statement, and these are at paragraphs 17 to 19 of the chairman's witness statement at D1176. and 1177. And 17, he discusses the points I made about his absence of his vagueness. But we don't believe they kept minutes of my meetings with the banks, which is correct. 17, 18. The actions have led to the disruption of the BBIH group's business. So a number of important parties have left or are unwilling to provide witness evidence. A lot of our details on what's happened I'm not aware of, hoping documentation with the claimants, and a lot of the documentary records are also incomplete. Many of their hard copy documents were stolen, and soft copy means there's no record of correspondence between him and the bank. So he says it's difficult, and it's some mitigation for that. Obviously, we've had very limited disclosure from NOR so far, and none from the other banks, so that would be remedied on disclosure. So we come back to the background prior to the meeting of the appellants always wanting more capital, working capital. Very unlikely, we say, it would not have been brought up. Azmi Ali must be lying, we say, on that point. The real prospect that he is. In the end, if he must or may well be lying about that, the chairman's evidence is not so doubtful as to lack all credibility, which is the test, of course, in paragraph 1, one of the tests, of course, in paragraph 100 of the Integral Petroleum judgment, which is at F1246. And we could just pick that up. Because we say the facts of our case aren't too dissimilar to the facts of Integral. In that case, it begins at F1220. In that case, the defendant bank sought summary judgment on its claim for repayment of a loan facility that was past its due date, relying on the formal paperwork which all supported their case, including acknowledgement of debt signed by the claimants. In the end, the judge, Mr. Justice Mulder, refused to give summary judgment because it was persuaded that a trial judge needed to investigate the claimant's claim that a prior oral agreement there was a prior oral agreement to vary the repayment date, although this agreement did not feature in contemporaneous documentation and indeed was not raised at the time by the claimants at the time when it sought more time to pay the debt. We pick up a bit of that at paragraph 70 of the judgment on page 1238, F1238. As to the correspondence in the term sheet, I accept that when on the 15th of October 2019, Integral responded to the term sheet sent by the bank, rejecting and putting forward its own term sheet, there is nothing stated in that email or the accompanying letter to suggest there had been any agreement to reach on a repayment plan, any oral agreement release. I also note that Integral's letter referred to 2 stages contemplated by the bank on its term sheet, and the first stage contemplated by the bank was not the agreement of payment schedules, but the execution of the acknowledgement of debt letter, the due diligence, the signing of the term sheet. So there's inconsistent with the documents, the case, but she was largely persuaded that there was an oral agreement by witness statement evidence on the second claimant and some oblique references and transcripts of calls to a new repayment schedule. And in the end, she came to the passage we rely on at paragraph 100. If this matter...
Yes, this is Umar from Lloyd Misho. Sorry to interrupt, sir, but I request Mr. Ornaldo to please speak a little slower once, because he's reading from the document and transcribers are saying that. So if I request you, sir, please speak a little slower.
Thank you for that correction. I will certainly do that.
Thank you.
And so we get to paragraph 100, where in this passage, well-known passage, she talks about if the matter is allowed to proceed to trial, the court will in due course be likely to hear evidence from Mr. Seisnabov, and he is likely to be cross-examined on the alleged inconsistencies. Now, she's referring to inconsistencies in his evidence. I'm not persuaded the credibility of Mr. Saitsnapov can or should be assessed at this stage. I note the conclusion of Burst J in Korma versus Hegler Plastic at paragraph 40, and she sets out paragraph 40 in full. I won't quote it in full for the transcribers. She says, I'm not, in that case, he said, no matter how much I may doubt the professor has faced up to the problems with his evidence, I'm quite satisfied it would not be right for me to rule on a summary application. His evidence is so doubtful as to lack all credibility. Paragraph 101, then, the judge in Mrs. Justice Mulder says, although he was dealing with expert evidence, the principle seems to me to apply equally to a witness of fact. And even if I'm wrong on that, in the circumstances of this case, in my view, the matter is not so clear-cut as to enable me to form a definitive assessment of the credibility of Mr. Saitsnapov. So like here, you had a preponderance of formal evidence, but also like here, we say on one side, sufficient measures of other evidence to cause the judge to be concerned about moving summarily without disclosure and cross-examination. And so overall, in that case, the judge's immediate judgment approach was impeccable, we would say, and displayed the sort of caution we would urge your lordships to adopt here. Put all this together on this ground, we submit that the judge's mini-trial approach was impermissible in these circumstances and flawed in its execution. Given all the circumstances, there simply was not sufficient clarity for the judge to carry out the exercise he did and decide the defendants had no real prospect of showing at trial that Norbank made the working capital on the 16th of December. And on the evidence I've shown your lordship, the issue of whether or not Norbank made the statement is unclear and can only be resolved at trial. Is not suitable for determination on a summary basis. And with that, I want to go to the agency point, my lord. Round one, agency. Now, turning to the question of agency,
Mr. Fraser, sorry to disturb you. If you're successful on this point, that the judge, the judge should not have made a decision against you based on the affidavits of two witnesses, one going against the other. You are successful on that, then your appeal should be allowed, and you don't have to go. The other issues becomes not so important, is it?
We would say overall, yes, your lordship could follow that route. You could, yes, your lordship could follow that route. You could say that because ground 6, there's a real prospect which needs to be identified at trial, that therefore you don't actually want to deal with the other grounds on a summary basis. You think they should all be decided against a factual matrix at trial. That would be the safer, less risky route, less risk of having an injustice on the other matters. And that is one route your lordship could do. And that, I suggest that, my offence to Peter Gross earlier, he said, I didn't think I'd be so lucky. But we say that is of course open to your lordships under your jurisdictional powers. So that's what the lordship was interested in.
Otherwise, we decide this in your favor. What about the other grounds that you raise?
Yes, well,
are they still necessary for us to make decisions on those other grounds?
We would say you don't have to, because you could. You have jurisdiction of sending all the matters to trial. My learned friend would say, yes, you have to go through all the other issues and matters and show that individually, as regards to each of those, the judge was wrong on real prospect. And I'm now going to go individually. If my learned friend is right, okay, you don't agree with that, I'm now going to go to the other matters.
I think the point, Mr. Fraser, just so we've got it clear, if you succeeded on ground 6, one approach is, well, the whole pack of cards comes tumbling down, you'd say, and the whole thing goes for trial. But another approach on ground 6, which is what was behind the question I asked you, was that might give you a good claim or an arguable claim against Noor. But so far as concerns the other claimants, if Noor wasn't acting as an agent, even arguably, then those counterclaims don't get off the ground. And they don't depend on the affidavit evidence on which you've won, in quotation marks, on ground 6.
Well, they do depend on a factual dispute that would be it is suitable for trial rather than an immediate judgment. So, and those the matrix would be all about of fact for which you would decide the agency. So decide whether the other syndicate banks are drawn in or kept in would be the same matrix of fact that we're going through on all the other points. And so, just because I just completed my answer, and so the problem would be if notionally your lordship's approach was adopted, is that you could have in a summary process, which is the risk of injustice, put it this way, is greater. It just is greater because you haven't got disclosure and cross-examination. You don't have the complete fact. So you risk a considerable injustice on this point, whereas the other, there is going to be a factual matrix, and really the whole thing would need to be discussed with the attendance of the other banks as well. That I think would be the way forward, because you would, if you were then discussing the matrix, matters came forward, no inconsistent findings of fact in due course of the trial, which affected the agency issue. That's how one way you could look at it. Going to the agency point then on its own, we submit that the judge's certainty, this is ground one agency, we submit that the judge's certainty that Norbank could not have been speaking at the meeting so as to bind the other syndicate banks was misplaced, and certainly at this summary stage. We say he made a number of errors here which illustrated that his certainty was misplaced and rendered his judgment unsafe on this point, whereas the real agency issue was unclear and deserved fuller investigation at trial. And we set this out fully in paragraphs 35 to 52 of our skeleton, which are, for your lordship's reference, are at pages A17 to A22 of the bundle, and we rely on those. And I'm just going to summarize briefly, if I may, why the judge is wrong now. Most importantly, we say the judge was wrong to find as he did, and we now want to turn to the judgment. In his judgment, paragraph 19, which is at B13, where he found there that Norbank could only have been acting at the 16th December meeting as the agent of the appellants, because it had been appointed such agent under the lead arranger letter. And you see there, paragraph 19, and I'll read this slowly for the transcribers. At the time of the meeting on the 16th of December 2018, Nor could only have been acting in accordance with the terms of the IMLA letter. No syndicate existed at that point. There is no logical basis on which the letter could amount to appointment by the other claimants of Nor as its agent when it was acting as agent for the defendants. The BBIH group engaged Nor on the terms of the IMLA letter to act on its behalf. It goes forward to set out his descriptions of the law on that point. So it's only under the letter, and only as such it was acting on the 16th of December. Now, we say this conclusion seems perverse, with all due respect, when you consider the only two parties physically at this meeting were the Norbank representatives and the appellant's representatives. And at this meeting, Norbank was making demands for further security to be supplied to the syndicate, failing which the syndication would not proceed. So while perhaps Norbank could potentially be seen acting as the appellant's agent under the lead arranger letter, dealing with the syndicate banks on that side, pulling in commitments, they're in the documents back in August and September. This analysis is completely misplaced when considering that Norbank was making demands of the appellants for extra security for the benefit of the syndicate on the 16th of December. Norbank were negotiating here against the appellants and seeking concessions from them. He cannot have been their agent at the meeting. The judge here,
Sorry, Mr. Fraser, why doesn't one simply characterise the sort of Occam's razor, Norbank acting like a broker, telling them what's going to work and what's not?
except that Norbank was demanding security.
Yeah.
This is actually in its own evidence saying we want security. It's just on our submission, it certainly can't be clear that it was acting for the group in demanding security to be handed over, which it then takes on the 25th of December, 10 days later. We say it simply cannot have been acting for the bank in our submission. And while we say it cannot have been acting for the bank at the meeting, it is perfectly possible, to put it no higher, that the Norbank could have been the syndicate bank agent, as it went there to argue about the terms of the syndicate loan, to get the syndicate loan over the line for the benefit of all of the syndicate loan, and if the chairman is right, made promises on behalf of the syndicate bank at the meeting to provide 350 million. Now, we don't know for sure on the agency point because the court has not yet had disclosed for it any communications between Norbank and the other syndicate banks, between them, leading up to this meeting and after it, indeed, which would tell the court much more. The court would expect to see such material on disclosure, and thus, correctly applying one of the principles in Easy and Opal, the judge should also have found that this was a good reason to make summary determination. The principle, which your lordships will all know well, but it's repeated again at paragraph 11 of the judgment at B9. It's the one from Doncaster Pharmaceuticals. Page B, paragraph 11 of the judgment, he sets out the judge at the bottom, Lewison's well-known passage in Easy Air and Opal, and in the passage, Little Roman 4 on B9. Although a case, Little Roman 6, apologies. Although a case may turn out at trial not to be really complicated, it does not follow that it should be decided without the fuller investigation into the facts at trial than is possible or permissible on summary judgment. Thus, the court should hesitate about making a final decision without a trial, even where there is no obvious conflict of fact at the time of the application, where reasonable grounds exist for believing that a fuller investigation into the facts of the case would add to or alter the evidence available to the trial judge and so affect the outcome of the case. And so in this case, plainly, documents passing between Norbank and the syndicate banks around this time would shed much more light on the agency part. In the end, the judge staked all on the importance of his point that Norbank was appointed by the appellants as its agent under the 1st of August letter, as you see there. But on close scrutiny, we submit it's not such an overwhelming point after all. If we go to the letter itself at D186, this letter throws up what we would say are some difficulties with the judge's analysis. The first one to pick up is paragraph 11, clause 11.3c Roman 4, which is on
D186, is it?
It begins 186, goes to 191, what I want to take you to.
Is Mr. Crossley about to take us there?
Sorry, D191. I hope my junior is about to take you there. Has he taken you there?
Thus prompted, yes.
And it's the paragraph, clause 11.3c. And the obliger represents the initial mandated lead arranger and the book runner. That, little 4, initial mandated lead arranger or book runner is not acting as a fiduciary for as an advisor to it in connection with the transaction. So that's not supportive of the judge's analysis. It's certainly not clear from this that the Norbank would be the appellant's agent and could not be the syndicated bank's agent by the time it came to December 16. The judge addressed this and said, well, it may not have been a fiduciary, but it's an agent in other respects. But it's certainly not a strong indication in the judge's favour. If we go to 14.2, and this in a way picks up my learned, to Roger French's point, 14.2, it's a dual agency point, which is that 14.2, the obliger and initial mandated lead arranger acknowledge that the initial mandated lead arranger or affiliates may act in more than one capacity in relation to this transaction and may have conflicting interests in respect of such different capacities. So it's acknowledged here that, in fact, even if an agent for the appellants, they could act with different hats on. Makes sense, as it was a lender itself and could speak for other lenders depending on the circumstances. So far from excluding Norbank acting as an agent for the other lenders, this letter actually specifically permits it. And indeed, that's in accordance with the law, of course, which permits dual agencies and transactions. It's all a matter of fact, which hat the agency is wearing at the time. And we have the authorities in the bundle boasted to paragraph 13 and 2033. They are at F441649 and F441666. So, of course, even if the letter did appoint Norbank as the appellant's agent in some respects at the beginning of the syndications in August, the leading textbook makes it clear this is not an immutable situation, but as the syndication enters into the stages of negotiation documents, the lead arranger can instead be perceived, arguably, as an agent for the lenders in such negotiations, always depending on the facts. And you're going to get support from this in McKnight on the law of international finance, which your lordships will find at beginning at F1923. Now, beginning on 19, this is McKnight Patterson F1923. Beginning on 1923, position of an arranger in an action on negligence. Now, they are examining here a related but slightly different question of whether the lead arranger can ever have a duty of care to the lenders. The textbook divides up the lead arranger role into two stages. The first stage is to commitment of the lenders, and the second stage is after commitment, while documents are being negotiated between lenders and borrowers. And your lordship sees that, just the passage at the bottom of 1923, paragraph beginning 9.4.4.1, a wide duty of care. In examining the question of whether an arranger owes a wide duty of care to the lenders, and if the necessary elements of reliance can be made out, it is convenient to examine its role in two stages. The first stage covers the period up until the lenders commit in principle to participate in the transaction, going on to finish the sentence. The second stage relates to the period in which the arranger is involved in the preparation and negotiation of the formal facility documentation. And the first stage, they say, it is submitted in respect of its role in the first stage, an arranger of a syndicated loan, which is acting in the pursuance of a mandate granted to it by the borrower, should usually be in the position, as addressed by Williams and Natural Life Health Foods, in that it is acting on behalf of the borrower, which is the judge's assumption, rather than purporting to accept his own independent responsibilities towards the lender. But if we go over the page, the situation gets more complicated depending on the facts. And at the second stage, 9.4.4.1.2, second sentence, first sentence, the position as to the second stage may appear to be less clear, because in the end, in terms of negligence, unlikely to be found liable. However, second sentence, it must, however, be conceded that it is very unlikely the arranger could, in any practical sense, be acting on behalf of the borrower once it has reached the stage of preparing and negotiating the facility documentation. So I think that addresses your point, Sir Roger. Accordingly, an argument in favour of the arranger based on Williams and Natural Life Foods is unlikely to succeed. And as that passage goes from by this stage all the way down to potential syndicate member needing to footnote at 149, I'd ask your lordship to read it yourselves rather than me torture the transcriber by reading it out. So the point being, the lordships had a chance to read this, the lead arranger's role changes in those stages from generally acting for the borrower towards acting in lender's interests. It shows that the position is far from being fixed throughout as the borrower's agent from a date as fixed by the lead arranger letter, which is effectively what the judge found. So for these reasons, we say, and for the reasons given in our skeleton at paragraphs 32 to 55, A16 to 22, We say the agency issue was not as clear-cut as the judge found, and he was wrong to be so certain on this issue, as his mistakes show, and thus we say the issue should go to trial. That's agency. I want to go on to affirmation. Your Lordship, affirmation. This is ground 2, and this is addressed in our skeleton at A23 to 28. Paragraphs 56 to 64, where we set out our arguments in support of it, and where we say that the judge erred in his approach. Ground 2 was wrong to find no real prospect of finding that the defendant had not affirmed the syndicate facility agreement, and that goes from paragraph 56 there to paragraph 64, where we say the judge erred in his approach and findings. We rely on those. The point I want to develop orally now is to emphasize how much the courts have warned against judges making affirmation findings on a summary basis before all the facts have been established at trial. 3 recent cases on this subject. In this jurisdiction, we have the Court of Appeal in which the Chief Justice sat in Hexagon in 2020, saying, and pick that up at F39, so F1591. The judgment begins at F1584, and it was considering an immediate judgment, including on an affirmation point, and in due course they overturned the immediate judgment. And it explains that on that basis it was too complicated for immediate judgment. The court in Hexagon describes the problems with the judge's approach quite early on in paragraphs 14 and 15 at F159. He said, His Excellency, they're recording about the judge below, recognised that the court should not determine the application by conducting a mini-trial, and sets out the law on that. And statements of principles were not really in contention in this case. That's the end of that paragraph. It's the passage beginning on paragraph 15. The difficulty of the judgment under appeal is that it involved conclusions necessarily based on the pleadings and sparse written evidence that were inherently fact-sensitive and required evaluative judgments to be made, which could only really be made in the context of a factual matrix and specific findings of fact identified after a trial of a claim. Those observations relate particularly to His Excellency's conclusions in relation to the character of the alleged breaches and whether they were fundamental or non-fundamental, whether there was affirmation of the contract by the appellant claimant notwithstanding prior breaches, and whether they're barred by operation of time. So Hexagon has identified affirmation as a problem, and in due course, going forward, I don't need to take the lordships there. He felt that the affirmation approach by the judge was wrong and that it was not a case for immediate judgment. That's paragraphs 81 to 86. In the United Kingdom, we have the Court of Appeal in 2019 in law debenture corporation against Ukraine, and that your lordships will find at F23, F1009 is the page number. It's where it begins.
Yes, sir. This is again Umar. I am really sorry to interrupt, sir, but it has been almost a 2-hour session now, and reporters are tired. So can you please tell me how much time really?
Yes. We have agreed, if this is, I hope this is okay, we've agreed with the Chief Justice that he has a prayer time at in 30 minutes time. And if the stenographers could wait for another 30 minutes, we will then have a break then. Would that be agreeable?
Yes. I will
alternatively, okay, maybe we can break in 15 minutes, but we will break for about half an hour so that I have about 10 minutes after 7:30 to do what I need to do.
Thank you.
So you can start earlier.
Let's
we
do
can stop in about 15 minutes.
15 minutes.
And then 1-5. And then we'll stop at half an hour or so. Is that all right with everybody?
Yes, my lord, that's absolutely fine. Thank you so much.
Good. Thank you very much.
In law debenture, the Court of Appeal there found that affirmation was unsuitable for summary judgment as it raised difficult issues of fact which needed to be investigated at trial. And we could start at 1-1 at paragraph 190. (1067). It is convenient at this point to deal with the affirmation issue raised by law debenture and its respondents' notice. Law debenture is, even if Ukraine's defence and duress is justiciable, Ukraine has engaged in acts which amount to affirmation of the notes after it was free of the duress alleged, prior to any purported acts of avoidance. The judge below, Blair J., considered this argument, declined to consider it on a summary basis, essentially for the same reasons for ratification. He dealt with the issue as follows, and it's paragraph 256, the quotation from that judgment, paragraph 256. In agreement with Ukraine, affirmation is unsuitable for summary determination. In order to assess the trustee's case, it would be necessary to conduct a mini-trial examining the various acts and statements relied upon by the trustee and Ukraine's reservations. And indeed, in due course, obviously, Ukraine's knowledge. Before us, paragraph 191, the trustee argued, as in our case, Mr. Howard for the trustee, that Ukraine had lawyers. Ukraine was a sovereign country. It had lawyers. It must have known of its rights and therefore be taken to affirm with knowledge of those rights. And that's what you see in paragraph 191. Before us, Mr. Howard relied upon the same conduct to support his case of affirmation. And makes the various points, and I think at paragraph 192, he goes forward. He sets out the argument there that Ukraine must have known because it had English adversaries readily available to it, and that's at 1068C and D. And at paragraph 195, going over the page at 1069, the court rejected this. We see no reason to disturb the judge's conclusions. We consider that at the least, even accepting that their conduct in paying notes could amount to affirmation, a trial on the evidence would be required in order to determine A, whether Ukraine had the requisite knowledge of its alleged rights to avoid the contract, and B, whether there was continuing duress and as to its effect. They're not suitable for determination on a summary judgment application. Couldn't really be clearer on that. In that case, even with all the expert legal advice in the world available to the sovereign country, it was not obvious that it must have known of its rights to assent. So it is not always safe to assume, as we say in our Scudder's argument of paragraph 59.2, that even with all the advisors' money combined, in a case such as ours, complex case, where the lines are blurred between breach or not, and where many defences are open to the respondents, the people within the appellants would have realised that the right to rescind had arisen. We say that our case is a fortiori to the Ukraine case. As a UAE businessman operating UAE companies in onshore UAE, even with UAE lawyers, is really unlikely to know about the English law of decision in such circumstances. Now, the third case takes us even further, and it's more recent. It's 2021, Mrs. Justice Cockrell's judgment in Leeds City Council and Barclays Bank. The Lordships will find that at F1862. And this case illustrates this is Justice Cockrell, and this case illustrates that it's not just difficult for the court to decide on a summary basis whether the appellants are aware, but also difficult to decide at this stage, and if so, when precisely, as it's only acts obviously after that date that can be affirmatory. Now, in the Leeds City Council case, by way of outline, the claimants claim to rescind their bank loans due to the LIBOR scandal, arguing that the banks had falsely represented their loans as being subject to honest interest rates. Now, the bank was able to strike it out, was able to show there was at immediate judgment level there was no plea of reliance on the relevant misrepresentations, and that's what we went. But they had alternatively sought, the banks had alternatively sought immediate judgment on the claimant's misrepresentation claim, rescission claim, on the affirmation basis. As they said, it's plain that the claimants had affirmed the contract by making payments of interest under it, with knowledge of the right to rescind after the LIBOR scandal became public. The judge dealt with this argument at paragraphs 164 onwards, page 1911. F1911. At 164, the fundamentals on the law of affirmation were not in dispute. We talk about rescission, and they must make a choice and so forth. 165, but the representee cannot exercise his right to rescind unless he knows that such a right has accrued to him. Hence, what is required is an informed election. The representee must have sufficient knowledge of its right to rescind the contract, and then he must manifest the election to affirm through words or conduct which objectively construed evince such an election. The parties hotly dispute whether the claimant's conduct can be taken as affirmatory and so forth. 167. In order to succeed, the banks must persuade the court that at this stage of the case, that is in advance of disclosure of witness evidence, it can be determined that claimants had sufficient knowledge of their right to rescind the loans, whatever their inattentions may have been by their conduct, they elected not to do so. Now, at 168, he says, it is not impossible for a case of waiver to be decided at this stage. And he gives an example. He says, a fairly unusual example of Barbara and Imperio, where there was no scope for disagreement as to the facts. That's at D. Barbara, therefore, represents, there was no question about the requisite knowledge. Barbara, therefore, represents a fairly unusual case. Certainly, it's far more common for courts faced with such arguments at this stage to refuse to grant summary judgment strikeout, often in quite dismissive terms. For example, in Law Dependence Trust against Ukraine, and then he cites that passage in Ukraine I've taken the lordships to. And at 170, and this is important, while it may not be the case that the Court of Appeal was intending to say that no case where such issues could ever be suitable for summary determination, this dictum provides a fairly clear hint that where affirmation cases raise questions of fact, for example, as to knowledge, they should be allowed to proceed to trial. And going forward into this case, because it's relevant to the question my learned friends bring up, at 20198, on F1918, she goes on to address the question of the claimant's knowledge. She's addressed the acts, as it were. The second question is paragraph 198 relates to the claimant's knowledge and the date of that knowledge. As to this, I was of the view that the claimants have considerable difficulties. And she goes on to then discuss as to 200, as to beginning of paragraph 200, but as to fixing a date, perhaps in part of the approach taken to what is requisite to know, and in part because of the stage of proceedings, the evidence is plainly lacking in detail. And going over the page at F191, paragraph 2, what is by far the most troublesome is the second part of the knowledge question, the knowledge of the right, and how that knowledge arose. And she goes on to consider how in one case affirmation was found because, and a date was given, because which is the more large case she refers to 203, because the case in that, it was in the middle of a court case. You're constantly seeing your lawyers, the surroundings. She felt those are fairly unusual facts. Actually, you see that in 204. The affirmation was said to have taken place actually within the defence in the action at a time when solicitors long since been retained when counsel had drafted the evidence itself. It was a case where no remotely tricky questions of knowledge arose. She then considers how the next case, involvement, doesn't take it any further. You see that from paragraph 206. And she concludes in fairly trenchant terms, and this is on Mr. Beltrami was making a submission, well, it can be inferred that if you have lawyers, much as my learned friend made here, as the judge found, if you have lawyers, you can be affirmed to have knowledge of his rights. while paragraph 207, while the point as to knowledge of the right was put with great skill by Mr. Beltrami, I'm not persuaded this line of authority should be taken as establishing the propositions for which he contended, or that wherever there is an in-house lawyer, relevant advice will, at the summary judgment strikeout stage, be inferred to have been taken unless the party waives privilege in relation to its legal advice at that preliminary stage. 208. In my judgment, the better view is that the authorities reflect a fact-sensitive approach to a fact-sensitive issue. Where a party is engaged in litigation, has litigation solicitors, more likely an inference. However, in their own case, we are operating in territory some considerable distance for this, 209, and they do have in-house advisors, but as he goes on to describe how it doesn't get them over the line on that test. In that way, and she goes on at 210 and 211 how they say they might win a trial, but not willing to go there at this stage. So she sees Ukraine as really excluding the sort of immediate judgment affirmation that the judge gave below, and we say in this case where there is a question of fact about our acts and whether they were made with reservation or they were procured by promises of working capital, and more importantly, our knowledge when the claimant in his witness statement said, I don't know about the rights, there's no evidence that anyone else knew at what time, and therefore this sort of inference that my learned friend relies on and the judge accepted just can't get them over the line, we say, to get them around the really strong judicial bars against granting immediate judgment on affirmation points. So yes, while we agree with my learned friend's submission, it is technically possible for immediate judgment to be given in respect to an affirmation issue. The direction of travel of the courts is to make this an increasingly rare event and not one the judge should have done on the facts of our case for the reasons we give in paragraphs 56 to 64 of our skeleton. Now, I was going to go on to another topic, but as it's 10 past 11, it might be a good time to break. And
but these authorities you just cited support your first submission, your first ground, isn't it?
Yes.
I mean that the matter should go for trial because the dispute of facts, basically.
Exactly.
On the agency, yeah, I don't know how they are related to your agency issue. These authorities you just.
On the agency issue, it becomes out of the matrix of fact. They're going to have to be decided at trial by a court as to whether they were acting under an agency of the syndicated banks or for the group or for the appellants or themselves. And that is quite complicated. You need to look at all the documents between the claimants, between the Norbank and the other syndicated banks, and we have none of that. And it's only out of that very difficult, complex factual narrative matrix will you be able to come to a decision on agency. And so it is a similar
Mr.
point.
Fraser, sorry, I'm always putting the bleak scenario.
You must do, my lord.
If you failed on ground one,
Agency.
even if you were otherwise overwhelmingly right on ground two, it doesn't arise. Is that right?
Yes, I think not as against.
Sorry, it's a bleak.
Not as against the syndicate banks.
Yes, that's the point. I'm just trying to keep track.
No, one should, yes. Well, unless I can, we'll short break.
Yeah.
Do I imagine then 30 minutes, 30 minutes time?
Yeah. Let's say my time is 7:45. Now I'm thinking of Mr. Justice Robert French from in Perth. He may want to take a dinner break, a simple dinner break, half an hour. Is that all right for you? Robert?
My wife's going to provide that when I get home, and someone got me out. Don't worry about that.
I'm glad if we can keep it more moderate than that. It'd be great.
Good.
So what time are we?
So start at 7:45 my time.
So that's 7:45.
30 minutes from now.
45.
Yeah. 45 past the hour, whatever.
45 past the hour, that's it.
That's right. Everybody ready, Ashada?
Yes, Chief Justice. Do we have the transcribers ready? Mr. Omar?
Yes, ma'am, they are ready.
Perfect.
Okay, thank you very much. Okay, yes, Mr. Fraser, you want to continue?
Yes, please. I'm going on to ground 3, duress. And we put in our written arguments, we address it at bundle in reference A28. And there's the paragraphs on our skeleton 65 through to 76, and we rely on those. The only point I want to develop in particular now, and it relates to the question of whether Norbank's admitted, and it's now admitted, threat to withdraw from the syndicate on the 16th of December, unless it got the OBN security, could at trial amount to duress. That is to say, to be duress, to be unlawful, an unlawful act, would have to amount to, as pleaded by us, to a breach of its obligation in the 1st of August lead arranger letter to use its best efforts to arrange the syndication. The letter is at, mind your lordships, D1 186 to 7. Now, the judge's conclusion on this is at paragraphs 44 to 45 of his judgment, that is to say at B21. And he, in essence, to paraphrase him, the conclusion was that the best efforts obligation, which we're going to rely on, could not have been breached by Norbank refusal to lend, essentially because the lead arranger letter itself made it clear that nothing in the letter constituted a commitment to provide financing. And if we look at the letter, you will see at the beginning of the letter 186, we, Norbank, and all our affiliates are pleased to set out in this letter the terms and conditions on which we are willing to use our best efforts to arrange and manage primary syndication of the facility amounting to 1.75 billion for the obliger. And next sentence, nothing in this letter constitutes a commitment by IMLA to provide any financing. Now, our arguments are that this placed, the judgment placed too much emphasis on that sentence in the letter, which as a matter of construction did not purport to constrain the best efforts obligation, and that the respondent's action could amount to unlawful duress, obviously depending on the factual circumstances to be established at trial. Now, what I want to flag to your lordship is the Jet 2 case we quote in paragraph 66 of our skeleton.
But before you proceed on, Mr. Fraser, before you proceed on, I've read a bit about on duress, but in the context of this particular case, where is that duress? Can you relate duress to the facts of this case?
Yes.
Was placed under duress.
Yes, it's
And
probably best
to sign an agreement.
It's probably best if you pick it up from the pleading, my lord, which is at C39.
Yes.
Bundle C, and it's paragraph 62, and then
the 39.
This is the defence, amended defence and counterclaim, yes. And then paragraph 62 and paragraph 65, and that sets out how the statements made at the meeting, which are contested but which we can establish, but at 62A you have the withdrawal threat, which is effectively admitted, and at 52B you have the working capital statement. 62A, if the claimant did not agree, chairman did not agree in respect of OBN energy being provided in favour of the 8th claimant would decline to participate in the proposed syndicate with the inevitable consequence of the circumstances where the security which had been provided to the 8th claimant for the bridge facility, including significantly the revenues of the Modumat labour camp, would not be available to the proposed syndicate facility, that the proposed syndicate facility would not proceed. That's the withdrawal threat, which is admitted. And then the working capital statement did agree to provide security. They would ensure that working capital would be made. Duress, out of that, my lord, if you go further down the pages at 65, in circumstances where it's set out above, the group was under very significant financial pressure, the withdrawal threat and the working capital statement together constituted substantial economic pressure upon the chairman on his own behalf to agree both A, to arrange with the security, and B, to propose with the syndicate facility on condition that they provided the security. And at 66, you see the pleading there about the pressure was illegitimate in circumstances where it was A, a breach of its duties to the other proposed participants, which we do not rely on and we would draw below, but B, obligation to use best efforts to arrange and manage the proposed syndicate facility pursuant to the letter. In the circumstances where, rather than taking all steps in its power capable of producing the desired results, being the steps that a prudent, determined and reasonable IMLA would take, that made the withdrawal threat, which was no such step, was rather a step which preventing proposed syndicate facility proceeding. Hope your lordship sees that. So what we were saying, I wanted to rely on is the Jet 2 case. We quote that in paragraph 66 of our skeleton argument at A28. And the point is, its proposition, its authority for the proposition, it's at F12. I'll take you to the passages in a minute. Its authority for the proposition that what constitutes a breach of an obligation of best efforts is a fact-sensitive issue, which is your Chief Justice's point, and thus we say it does not lend itself to summary judgment. But also the obligation is a heavy one, which can require the obliger to act according to their own financial interests. And we could pick this up in page 317 of F317. And in that case, the question was whether Blackpool Airport was obliged under a best efforts clause to provide out-of-hours flight slots for Jet 2 budget airlines, so Jet 2 could make more money, so it was cheaper, but it was going to cost Blackpool Airport quite a lot to do it. And they said, well, we're not obliged to do that because that would be against our financial interests. And the judge, Morbick's judgment at paragraph 32 is on page 317 starts. It was a central plank of BAL's argument before the judge, and that's the airport, that the obligation to use best endeavours did not require it to act contrary to its own commercial interest, which in the context of this case amounts to saying that BAL was not obliged to accept aircraft movements outside normal hours if that would cause it financial loss, and there is some support for that he goes through. However, if you go through starting at E, I approach with some caution the submission that BAL was entitled to refuse to accept aircraft movements outside normal opening hours if that caused it to incur a loss. Because on the judge's finding, the ability to schedule aircraft movements outside those hours was essential to Jet 2's business and was therefore fundamental to the agreement. So according to the factual basis, the factual matrix of that case, it was essential to the business, and that's why he would approach with some caution. So you would not have expected the parties to contemplate the airport should be able to restrict Jet 2's aircraft movements to normal opening hours simply because it incurred a loss each time it was required to accept a movement outside its hours, because keeping the airport open outside normal hours proved to be more expensive than it had expected. So that's, as at the time of the agreement, you can see factual matrix. If it's important to the business, you may have to set that one up, the airport. On the other hand, and this is important, I can, just above G, I can see force in the argument that if, for example, it were to become clear that Jet 2 could never expect to operate low-cost services with Blackpool profitably, BAL, the airport, would not be obliged to incur further losses in seeking to promote a failing business. So therefore, as a matter of factual investigation, if in due course, post the agreement, it became clear that actually the circumstances at the time of the breach, it was running a loss, then you might say that it didn't matter the best efforts. It couldn't amount to operating outside. So both matters of fact, both at the time of the agreement and thereafter. So in our case, whether Nor Bank was in breach of its best endeavours obligation as lead bank by threatening to torpedo the syndication 4 days before it was due to complete, unless it received extra security, must be a question of fact and law that requires more exploration of the circumstances of the contract back in August 2018 with this letter, and then the circumstances of the breach in December 18 at the time of the withdrawal threat. On the surface, at least, we say, it looks quite possible that such conduct was the antithesis of the lead arranger using his best efforts to complete a syndication deal. Even more so, we say, as evidence suggests that extraction of security damaged the group's chances of complying with the terms of the syndication, as it could not raise any other working capital to survive. And you'll get that out of the chairman's witness statement, paragraphs 47 and 49 at D1183 and D1184. Now, against that scenario will be the statement in the letter the judge found that nothing in it constituted an obligation on the lead arranger to provide any financing. But we say that will be just one part of the factual matrix for a trial judge to consider in due course. Whether or not that sentence enabled Norbank to act as it did on December the 16th, 4 days before completion, will be the subject of further evidence and vigorous debate at trial. It is not dispositive on its own, we say, because Norbank's conduct was not simply refusing to lend, it was also refusing to hand over security that would enable the syndicated finance agreements to proceed and not lend unless it received further security that would damage the group's future chances of complying with the terms of that syndication. Neither of us, we hope your lordship can see, seem engaging in best efforts to arrange the syndication, especially when the factual background to the 1st of August letter made it clear, as your lordships have seen, that the appellants needed more working capital, which was not otherwise getting out of the syndication, in which it needed the OBN security for. So you can imagine experts at trial might well opine that Norbank could have sought security in another way, which did not so jeopardize the appellant's future operations, and thus their actual demands were not best efforts, or something similar. We say this was an error of construction by the judge, sufficient to vitiate his finding that we had no real prospect of proving duress at trial.
Why isn't this purely a question of construction?
Why isn't it?
Yeah.
Well, it is a question. It is a question of construction, but it's a construction against a factual matrix, and we say the factual matrix is not complete. It is a question of construction in a way your lordships are as good a place as a judge to come to a view on it. But the point I'm making is it's not the factual matrix is not complete, and that's what one would want to explore at trial. But we certainly feel that we have an argument. It can't be certainly against us in the way that the judge found. That's how we would put it, my lord.
Is there a hint of some counterfactual anywhere in the argument of what Noah might have done?
Well, if maybe I can think about that and come back to your lordship on another way. But how else it might have obtained its security, put down its lending, what other scenarios will depend on the facts we establish at trial. But it's reasonable to presume that experts would be examining all the possibilities and seeing what else can be done, and hence that's how we will put it.
Yeah.
Right. Okay. In the time available, I'm going to go on to misrepresentation at ground 4, and that is dealt with at paragraphs 77 to 81 of our skeleton. Pages A29 to A31. So by way of reminder, we say that the evidence, chairman's evidence, is about a promise to provide 100 million made by them. We say that promise in our paragraph 72 of our skeleton contained within it an implied representation that Norbank had reasonable grounds for making that promise. We say it was negligently made because it was not, in fact, in a position internally to guarantee such a payment, and they must have known that, or ought to have known that it had no reasonable grounds for making that statement. Now, we set out in paragraph 77 to 80 of our skeleton our case on how we say the judge erred in dismissing at a summary stage our case in negligent misrepresentation arising out of the working capital statements. And the judge's findings are B23, paragraphs 48 to 49 of his witness statement. Oh, sorry, of his judgment. Remind your lordship. Now, in that, he effectively found that there was a promise. And there was no representation of fact or opinion of any state of mind. It was a promise said to be a guarantee. It was an undertaking to provide working capital. This is not a party of events that occur in the future where it had no control, but it was providing an assurance. I do not find any assistance in the authorities cited to me, and I'm unable to see what statement of fact or future has the subject of a representation. Now, our point on this, as we set out in the skeleton, is that he was wrong to decide that the working capital statement could not have been a representation because it was a promise to do something, not an express representation of opinion or state or state of mind. In other words, he wrongly treated the two things as distinct. As you see, he went on to say he didn't get any assistance from the authorities that had been cited to him, whereas I had cited to him Foodco and Henry Boot, and containing within it Lord Wilberforce's statement of British Airways Board and Taylor, both of which were authority for our proposition, at least, that an implied representation of fact can sometimes be discerned from a promise, and thus should have been of considerable assistance to the judge. In Foodco, your lordships will know it, but I'll just briefly go to it at F10. It starts at F153, but goes forward to F192. And there's the judge just does a very erudite exposition on the realms of mythology and literature at paragraph 193. The law has been wary of imposing liability for statements about the future. Of course, a representation that something will be done in the future cannot either be true or false at the moment it is made. And although you may call it a representation, if it is saying anything, it is a contract or a promise. Similarly, in Tudor Grange Holdings, Brian Wilkinson said a representation of future conduct has no effect unless it constitutes a contract. Now, 196, although a bare prediction does not attract legal consequences, a statement about the future may implicitly contain a statement about the present. But as with all cases in which the court is asked to apply terms, the court must be cautious. So caution is there, but it is possible, as Lord Wilberforce observes in British Airways Board and Taylor, a statement as to existing fact that may be true. My lords, the distinction in law between a promise as to future action which may be broken or kept and a statement as to existing fact which may be true or false is clear enough. There may be inherent in a promise an implied statement as to a fact, and where this is really the case, the court can attach appropriate consequences to any falsity in or recklessness in the making of that statement. Everyone is familiar with the proposition that a statement of intention itself may be a statement of fact and so capable of being true or false. And the start of 197, when the verbal representation is there as the starting point, is plainly the words that actually used meant more than they said, and so forth. So, and we rely on the passage that 197 going forward to 198. It would not, I think, be difficult to say that in most cases the prediction about the future, particularly in context of contractual negotiations, would necessarily be understood as implicitly representing that the maker of the prediction had an honest belief in it. The existence or otherwise of a belief is a present fact that at the moment that the prediction is uttered, if therefore he does not have an honest belief in it, then he would have made a false representation of fact, or if he didn't have reasonable grounds, they go on to make, and that's the negligence side. Now, in that case, we see, and I'll show you, promises were made from Henry Boot, which was about its performance, what it would deliver, and the court did find that they included representations of fact, and you can see this. We go back to F188. There were two representations which were found to have been made in due course. Representation number 3, that's the brochure supplied by Henry Root for the service station, represented there would be a travel booking service and tourist information centre within the development, and or by implication that Henry Boot had an honest belief and reasonable grounds for believing that the development would include a travel booking service and tourist information service. And brochure 2, that the site would have a live departure information for all cross-channel services and implication that they had an honest and reasonable grounds for believing that it would have that. And as you will see going forward, the other representations were more predictions of footfall, which is slightly out of Henry Boot's ability to deliver. And if we see it going forward to 223, At 223, he accepts the representation about that it was made as regards on a belief about the tourism information and travel booking services. And at 224, he accepted the representation was made and reasonable grounds were for about the live departure information.
Can you, sorry, Fraser, can you just tell me what is the representation of fact implicit in the working capital statement, which lacked reasonable grounds?
The representation was that Norbank had reasonable grounds for making the promise that.
Well,
it had the statement of fact was implied representation. It's in paragraph 72 of our defence and counterclaim.
Well, look, you can. I mean, we're pretty familiar with this. We get a lot of it in our misleading or deceptive conduct jurisprudence in Australia, and ordinarily one expects to find an implied statement of fact, perhaps as to capacity, present capacity, future capacity. And then the question whether there may be a question as to whether there are reasonable grounds for making that, an implied statement supported by reasonable grounds, but just reasonable grounds floating in the air doesn't seem quite to cut it to a statement of fact that you can get your head around. I mean, is that it? It's just that.
Yes, it's at C41.
The fact that I have reasonable grounds for making this promise.
It's what it is. It's in paragraph 72 of our pleading. We say the 8th claimant guaranteed that it would provide the working capital to the group, which statement carried with it an implied representation that the 8th claimant had reasonable grounds for making it. And we then set out the reasons why it did not have reasonable grounds for making it at paragraph 74.
And what were these reasonable grounds? These were its practices, its appetite for risk, and so forth.
Well, it's implied representations that it knows what's going on inside Norbank. We don't. They are in communication with their credit committee. We are not.
That gets pretty close to an implied representation as to intention, because you can't have an intention if your appetite for risk and your internal practices are inconsistent with delivery of the promise.
But it could be it could be if they had reasonable grounds. They could be saying they have reasonable grounds for that a credit committee would approve it, a Norbank credit committee would approve it. And what those grounds are is whether they are reasonable or not is another matter. Now, the internal correspondence indicates that quite a few people within Norbank were not supportive, but there were some who were supportive. And
this is a statement of no present corporate intention, because this is an attributed intention. Yeah. So that's pretty close to a statement of fraud, isn't it?
No, because let us say that the person making the statement at the meeting is a member of the syndication team. So he's one part of the bank, and there are other parts of the bank, which is the credit committee, who are a black box to my clients, and he says, because he believes that it's possible that this money will be delivered, and it's representation, he believes that is what the bank's intention. Actually, it's probably not the bank's intention, and he didn't have reasonable grounds for doing it. But it wasn't a dishonest statement in the sense that he knew the bank wouldn't do it. I mean, there were grounds for thinking that the bank might do it, but once the lending was reduced or once the security was got. I don't think at this stage it's black and white, fraud or not fraud. I know the judge was interested in that.
It's a representation you're attributing to the corporation, whatever the internal processes which get us to that attribution. Anyway,
I too am struggling a bit with that for the similar reasons. I'm just trying to see how many hypotheses are piled upon each other to get your case. They deny making any statement, so we've got to assume that they did.
Yes.
Then we've got to assume. Hang on. So forgive me. Then we've got to assume, as you said to my lord a moment ago, that one part of the bank didn't know what the other part was doing, because otherwise it strikes me as it's fraud or bust. And you're not pleading fraud.
No. So
I'm struggling a bit.
The judge is right. When there is internal evidence, and we refer to it in our skeleton, that the decision wasn't all wasn't all one way.
No.
The evidence wasn't all one way about, it's paragraph 80 of our
Thank you.
Of your skeleton.
Yes.
Yeah. Okay, well, I've put the point.
You got the point. I'm sorry.
No, I said I'd put it.
Oh, you've said.
Yeah.
It is, of course, to some extent, a scenario upon scenario, but this is where we are in this application.
Okay, thank you.
So, and that is how we put it in terms of the difference in the middle. So that within Norbank, but you can see that there could be grounds for negligence rather than fraud. I think that I will have to go on to collateral contracts, if I may. Now, at paragraphs 89 to 92 of our skeleton, '83 to 82, we set out why we say the judge was wrong to dismiss our collateral contract argument at this summary stage. Namely, he failed to address our part performance argument, and he was wrong to find that the contract was too uncertain to enforce. We rely on those paragraphs, and I'm just going to develop the part performance argument. It's based on the following proposition. It's based on the fact that, as we have seen, in response to the working capital statement, the appellants provided the agreed security over the facility on Christmas Day within days of the demand, as in less than 10 days, in expectation of the banks or Norbank providing the extra working capital, but none materialised. I've shown you the evidence on that. In these circumstances, we say the courts can be more willing to find that there is a certainty of contractual terms, if it can. And Lord Templeman made this clear in the well-known terms in the Court of Appeal judgment in Sudbrook Trading, which I'll just quote for you. It's in paragraph 87, page 34 of our skeleton. Where an agreement which would otherwise be unenforceable for want of certainty or finality in an essential stipulation has been partly performed so that the intervention of the court is necessary in aid of a grant that has already taken effect, the court will strain to the utmost to supply the want of certainty, even to the extent of providing a substitute machinery. Now, we made the point below, and also by reference to the Supreme Court's decisions in the RTS and Molkerai case, which was really more applicable to fully executed case where both parties have performed obligations, although there is a reference to partial execution by one or the other. So Molkerai wasn't completely on point, but it made in part the point that we were making. But we definitely made the point about part performance. It's a reasonable argument, and we did make it. I just asked your lordships to see it in the transcript. Is it E172? So that was on day one. Within this side agreement, this is me, I'm speaking, without this side agreement, this is the middle of the page, that was supposed to have been drafted in good faith, but my clients arranged for the OBN security on the 25th of December. The Lordship knows the authorities and that part performance by one party is much more likely to make an unexecuted agreement required to be binding, and that is what happened on the strength of this. It also adds credibility to the fact that these promises were made and even believe they had authority because he went ahead and did it. I think it is a pretty strong point on this, and so he thought they had the ability to do that. At 183 to 4, again, there's a reference to it. At this point, I'm looking at the email, the January email, December and January emails. At the bottom, page 183, Mr. Fraser, what these emails are about are they're coming up with something on paper to record what was agreed. And there are a lot of emails about grasping their way to the process. And it is not finally done because Mr. Ali frankly admits they did not need to do it now. Why? Because they had the security, because 9 days later we gave them security. We say our reliance on the promise. And they thought, well, now you promised, so to speak. The agreement never gets done. We are happy with that. That is on one view what actually happened. My learned friend is effectively praying an aid their client, arguably welshing on the deal, and says, we never signed this, there was never any agreement, and we got the security, so we are sitting very pretty. Actually, the court should be holding them to their promise, really, and so we would ask you to look at it in that respect. And again, at 186, I say it forward, Mr. Fraser, that was very, very quick. As I say, I'd made the points, but we did our side of the bargain, so they should be held to their agreement. It was not done, it was never done. And again, the next day, 267, starting on 266, everything was being done in a hurry. Then both parties need a quick deal, especially the bank, to get security foreclosure. So it's not improbable that a legally binding contract, I think that means, will be inferred. Especially, as I said yesterday, the group in good faith acted on it and provided with security. And go on to say the next passage. And again, at further passages at 272, middle of 27, towards the last third of 270, going back to the question of a concluded contract. Obviously, it is partially executed, and it will. The court is more inclined to conclude that there was a contract, and so as in the middle of this. And then he talked about the issues when you've got it. He has the judge acknowledge that the issue often when you've got a partially concluded contract is whether what was the actual contract. And 275. I set out again. We go back to the question of the partial performance. So the point being that the appellants, as I say, having supplied the security with the respondents promising an agreement would be forthcoming, but never transpired, we submit that a trial judge would be certainly interested in supplying any alleged want of certainty. After all, on the chairman's evidence, the sum was agreed at 100 million. A timetable was agreed at the end of March. Security, there's no need, as the OBN is the security. The period of loan will be gleaned from the main agreements. And then we think there must be a prospect of the trial judge being more robust, and indeed is as pleaded as a performed agreement. Now, as your lordship sees in paragraphs 51 to 52, he said that he didn't address the part performance argument, and in his refusal judgment, which is at B41, paragraph 11, last sentence, he says no case of part performance was put forward, but I definitely did, however inadequately, put forward an argument of part performance. So we say a mistake here is sufficient to undermine his judgment. After all, part performance argument was a reasonable one, which deserved addressing, might realistically have interested a trial judge. And I've just got, I think, 15 minutes, and I want to do the Murabaya material or develop those. I think I simply have to before I finish, which is ground 7. So on the Murabaya, on the Sharia points, we address those at paragraphs 101 to 124 of our written skeleton, and we rely on that. The time remaining to me, I just want to focus on 2 points orally, namely whether under the English law of construction the appellants have a decent argument that the syndicated facility agreements incorporated the ELFI standards, the Murabaya agreements did, and if so, whether the judge should have proceeded to determine the issues in the absence of Islamic expert evidence. And in doing the second point, I will then make our application to admit the evidence of Mr. Edge, the Islamic law expert. But I don't need to get there until I go to that second point, so I can postpone that for the moment. So as to the first point, we say that the judge was wrong to construe that the term Sharia, as used in the Islamic finance doctrines, did not expressly incorporate the ELFI standards, because he wrongly decided that compulsory compliance with ELFI standards was not a part of the factual matrix of the Murabaya. And that in his judgment is at paragraph 91 on page B35. And in essence, and I'll come to that, his view was that the resolution applying the standards gave them a let-out under paragraph 2, and I'm going to make the points why he couldn't have really come to that conclusion, or shouldn't have come to that conclusion so firmly. And we developed this argument in paragraphs 104 to 110 of our skeleton. And what we say, it's common ground that the defendants operate as regulated financial institutions in the onshore United Arab Emirates, and as such, they were subject to the 4th of July 2018 decree of the central bank, and that can be found at F1628. Central Bank of the UAE HSA resolution regarding the adoption of AOFI Sharia standards. After greetings, the Higher Sharia Authority HSA resolved that 1. The Sharia standards issued by the Accounting and Auditing Organization for Islamic Financial Institutions shall be binding on the internal Sharia control committees of the financial institutions that perform all or part of their activities in accordance with Islamic Sharia rules from the 1st of September 2018 onwards. These Sharia standards represent the minimum Sharia standards for IFAs in all their activities and operations without exception. This is applicable for all existing AOFI standards, and standards will be amended or issued by AOFI. The ISCCs must comply with these Sharia standards in all of their fatwa issuance and adoption, approvals and recommendations in any form. The products, and that's the blanket application from the 1st of September 2018. And in paragraph 2, they then go to address the question about existing products out there. The products, activities and services adopted and currently used by IFIs prior to this resolution should be revised in accordance with AOFI Sharia standards based on a time plan that should not exceed by the 31st of December 2020. IFIs are required to submit their detailed revision plans to the Secretariat no later than the 31st of December 2018. Now, the judge decided in paragraph 91 that the agreements in question that we're looking at were a pre-existing product, which fell into paragraph 2, where compliance was negotiable with the Higher Sharia Authority over a 2-year period at the end of 2020, rather than future products, which would fall into paragraph 1, where it was not negotiable, but absolute from the 1st of September. But there was no evidence before him that those agreements were pre-existing products at all. Indeed, it seems that if I look at it, it looks like a bespoke agreement. And that's what we say in our skeleton at paragraph 106. So we say this was a mistake to decide that paragraph 1 did not apply, at least to decide that on a summary basis before trial established the correct position. Had he decided correctly that paragraph 1 did apply and that Noor Bank's transactions were subject to the standards from the 1st September 18, then we say that his earlier conclusions in paragraph 87, that the AOFI standards were not incorporated, would have suffered as a result. And so in this respect, looking at that question of the matter of construction, the question your lordships has faced with lordship below was, and your lordships are now, is whether the references to Sharia law in the master agreement, recital C, and then as they are defined, would be construed against the proper factual matrix investigated at trial as importing the standards. And to frame that argument, we should go to the documents themselves, which are at D676 and D680. And we begin with recital C, page 676. Under the Islamic facility, the investment agent will purchase commodities and sell them to the purchaser at the cost price, together with a profit element on a deferred payment basis, with the passing title immediately to the purchaser, all in accordance with the Sharia. And it's that phrase, all in accordance with, that's going to become important in the lives of the authorities. And at 680, we see the definitions of Sharia in the middle of the page. Sharia means the rules, principles, and parameters of Islamic law. Now, our argument is that in circumstances where the factual matrix includes the respondents as UAE financial institutions, the appellants as UAE group borrowing from UAE banks, the Islamic banks here, which is the 7th and 8th respondents, required to operate under Sharia law when issuing facilities, and their transactions, those banks' transactions are subject to the standards post the 1st September 18. There must be a real prospect that we could show at trial that references to rules, parameters, and rules, principles, and parameters of Islamic law would mean Islamic law as implied under the UAE regulatory finance law, which would incorporate the standards. Now,
but Mr. Fraser, you could have shown this at the hearing of the intermediate, the hearing that you had. You could have proven this is question of fact, isn't it? Not factual. It's not factual at all.
It's obviously going to be a factual matrix in the end of around the 27th December of what these words mean. And at a summary basis, the judge decided that they couldn't import them for the reasons he gave. But we say the reasons he gave were not good reasons, and that actually at trial, it's a reasonable argument to think, of the facts established at trial, that a trial judge might disagree and might actually think as a matter of construction that this
whether the judge agrees is another matter. But it is a question of fact whether this particular agreement falls within or is outside the scope of that law. It's a point of, is 100% legal. It's not factual at all. The agreement is there. You can show from the agreement that it didn't comply or it did comply with the law you cited earlier. You don't have to go for trial to determine that. I mean, you don't need to produce witnesses.
In a matter of construction, it's right. Your lordships are in as good a position as a judge below on a construction point to decide whether or not, as a matter of construction, which is why I'm trying to make the construction point now. But of course, construction points are, in general, decided against a factual matrix, and I've made some submissions on the factual matrix, but they're obviously, it's going to be more developed at trial, where more is known about the factual matrix. But I think I've got to show you that there's a reasonable argument here, and that the judge's reasons for dismissing it were wrong. So if I can just complete the construction point, because we're trying to make, I would be grateful if I can get to it, which is that if the authorities show that express incorporation relies on a type of wording that we say the lordship can find here, and that is when you get a wording like governed by or subject to a set of rules, and that might be enough for express incorporation of the regulatory rules. And the lordship gets that from the Target Rich case, which is in the bundle at F1128. And in that case, F1128. That's Mr. Beltrami sitting as a. And in that case, they were considering whether the conduct of business rules FCA handbook could be incorporated into a contract, and into the contracts they were considering. And the question was, what type of reference was necessary? And in paragraph 95, Paragraph 94, the judge said, there are some cases in which a background set of rules has been held to be incorporated into an agreement by the use of express words. And he then cites Larissa Chigi, which Justice Thomas J. held that a document which stated that transactions would be governed by a code of conduct achieved incorporation, or in Brandeis Brokers, there was an agreement that said to be subject to regulatory rules could have the same effect. So that's on one side, the good side of the line. On the bad side of the line are other cases, in which he says are the majority of cases normally, where references are made to the rules, but on a more general basis. I simply referring instances where regulatory rules are simply mentioned or described in a set of terms are not generally enough. They are not. It just becomes an audit of terms in effect, and that is not sufficient. And that's his point in paragraph 27 and 97. In their case, there's simply a lot of references to the rules, but there was no phrase such as governed by, subject to, or we say in accordance with. Here we say it's in accordance with similar language to subject, governed by, or subject to. It's certainly stronger than the paragraph 95 examples. So we say we are or we may be within the paragraph 94 examples, or in that case by that judge. Or if it's not clear, we would need to be resolved at trial against the factual matrix, which is your Lordship Chief Justice's point. Hence, we say our conclusion at paragraph 104 in our argument. So we cannot conclude at this stage on the summary basis. We say that the factual matrix of trial cannot bring this implication into the contract. Now, I want to. I'm conscious of time, but what I want to do, if is simply make the application to admit edge, because expert report, because it's relevant to the question of whether the judge was right to ignore the registrar's direction on adducing expert evidence. And
the academic, there's a real question whether it constitutes expert evidence in any way known to the judicial system. It seems to have a lot of gratuitous argumentative commentary, and for myself, I wouldn't give it very much weight at all, if any. We used to have a rule in the Federal Court in Australia that expert testimony could be treated in whole or in part as submission, and that's the best that I would be prepared to look at it, speak for myself.
Yes, I can see it's not all on point. I could certainly see your Lordship, the force of your Lordship's submissions on that point. But I think there are a couple of key passages in the evidence as we're talking about it. We could just quickly look at it because it goes to the question about whether it should be admitted as well.
Is this a good use of your time, Mr. Fraser?
Well, I'm really out, so I think I've got to try.
Maybe we're conveying a certain impression.
You are conveying an impression, but I feel I just need to make the point about why it's relevant, and then if your Lordships will let me, because I can see when you first read it, you'll think this may not be what we're after, but reading
also, Mr.
What was that?
That was on a second reading also.
Well, let me try. So. His point, the nub of his point, the important nub of his point. I mean, he's a distinguished expert. He's got the expertise. It's whether this is his best report, but he has his expertise. But paragraph 15 is the one we rely on. And the judge also urges his interpretation of the AOFI standards. The AOFI standard 30 is not limited in the way the learned judge suggests to Islamic banks, directly providing Islamic finance to conventional banks. A limitation of this nature would negate the effect of the standard to the whole practice and market for the Tarawak. And then he goes on to say, and in fact, this has now been specifically condemned. And his point there, and I think it is worth considering, is that the relevant standard is phrased in a particular way, that is to say that, so as we say, I'm sorry, in paragraph 105 of our 105 of our defense, let me just remind myself. Yeah. Basically, what our pleading is, and what he's backing up, is that by lending by Islamic banks under the master agreement offended 3.2 standard because paragraph 2 of the master agreement made it the master subject to the common terms agreement. Paragraph 3.1.1c of the common terms agreement specified the purposes of the facilities was to repay the company's existing indebtedness. That's what's going to happen. And that is going to include repaying conventional facilities. It's not in dispute that that's how it was used. So therefore, looked at overall, it was Islamic lending intended to be used to repay conventional interest-based lending in breach of the 3.2 standards. We say it offended the basic meaning of the standard, which is to stop Islamic lending benefiting conventional banks. If you could get away with it by inserting a middleman customer, as here, then the standard becomes easily subvertible and toothless. And this is what Mr. Edge calls a standard industry murabara, which acts by replacing the debt with another. And he said the standard was intended to apply to this practice, or else it negates its effect as the whole market. So it is expert support. And in effect, what he's saying is the judge adopted too narrow interpretation by saying it only applied to direct lending and not indirect lending. And he is an expert. And we say you couldn't be confident with that advice, with that opinion that the judge is right, and not so simple to permit the judge to decide on its own without expert evidence. If he is right, and if there's an argument there your lordship is interested in, then of course he also, at paragraph 14, sets out how recent cases in the Dubai cassation case said that a breach of the standards has been treated as illegal or a contractual nullity.
That's not accurate. It's not. There's nothing about the standard in there. Sorry to interrupt.
Sorry, the breach of Sharia. I'm so sorry. My learned friend is quite right to pick me up now. He in 14, and we read 14. Yes, in the case he says the case of the standard would contravene that. And in a famous case, he said that the violation of the strict principles of the Sharia in Islamic transaction would be taken seriously and could lead to a nullity. So it's not necessarily a standard, but it's breach of Sharia law. But we say standard is a part of Sharia law as applicable. So that's how you would get there. So you would get to the nullity argument of the contract in this route. So if you could see, I hope, that his evidence was sufficiently influential to be of interest to the judge had we been able to get it before the judge below. Now, we were not, and we didn't. And the question is, were we wrong to do that? Because that's not in accordance with the Ladin-Marshall Principle 1. And in that respect, we say that where the registrar's direction, which I think your lordship has seen, or lordship will know about, is to the effect that you have to adduce expert evidence on Islamic law issue, and that's at F1626. Registrar's Direction number 3 of 2017, expert evidence of Sharia, dated 15th of December, expert evidence of Sharia. And the background he sets out to the direction is pursuant to the rules, giving of expert evidence is regulated in the manner prescribed. This may be relevant, for example, in the context of a diff trust. And he then goes on to describe the direction and describes issues regarding identification of the relevant Sharia principles may arise by the trust instrument. So these are examples, but it's not so confined. The direction itself is whether requirements of Sharia law are relevant to matter before the diff courts. These are to be established as a matter of expert evidence and seek to place for the particular hearing. So on the face of it, of that direction at least, which postdated Fidela for this year, would be a requirement on the courts to decide matters with expert evidence. And so relying on that, and it's put up there on the diff website, and it's, you would imagine, expects to be followed, and the judge, we would say surprisingly, didn't follow it. Is that sufficient to excuse us not adducing this evidence below if we relied on the direction? And we say, we submit that it is. My learned friend characterises it as a gamble, and therefore that we have to live with that. But we say it's not a gamble to rely on what the diff courts rules say. If anyone gambled, it was the claimants who chose not to adduce expert evidence despite the requirements of the direction. And I think, so that's why we say we hope it can be admitted. Its relevance, therefore, I hope it goes to the question of breach. It shows that the issues were complex, more complex than the judges thought, which is another reason why we say he should have admitted the evidence. And it goes on to the question of breach and why the judge is wrong. And for the reasons of my skeleton argument, which I commend to you, that is why we say the judge's decision on the Marabra should be overturned. And I think I'm well over my time, but I've at least covered the ground.
Just might mention on that last point, there's been some discussion of the approach to questions of foreign law, including onshore law in nest investments, which has recently been posted decision of this court.
Right. Now I'm grateful for that, Michael.
Thank you.
Thank you.
Thank you very much, Mr. Fraser. So we're finished with Mr. Fraser. Mr. Montague-Smith, I don't understand this timetable that was given. We're supposed to take a 10 minutes break and then you're supposed to make a submission. But I thought you're also making submission tomorrow. What is there?
Yes. Well, I think the idea was to give us both, my lord, even time. And in order to do that, Mr. Fraser was going to finish about half an hour early so I could get ahead and make a start on my submissions. And then taking into account breaks tomorrow, he could then have a bit of time to reply. If he takes the whole of the first day, then I will get much less time than he will. That's the point. That's why we agreed to meet. I mean, it sounds like we've got a little bit of time left. And what I was going to try to do, with your permission, is deal with the agency issue if I can. I may not finish it, but I think it's worth using the time if your lordships are happy to sit for the time that we have.
No problem. So how many minutes more have you got? 15 minutes, is it?
What about 20 minutes?
Excuse me, Mr. Fraser, I'm okay. I can sit for another 1 hour, half an hour. It's no problem for me. No problem for me at all. I don't know what Mr. Peter.
I'm happy with my learned friend taking 20 minutes.
I'm
fine. Justice French. I don't know whether, but I'm fine. I'm okay.
It's early in the day where I am.
Yeah,
I'm very grateful. I mean, there is a lot of grounds to cover, as my little friend Mr. Fraser has shown you, and so as much time as we can have, we'd be grateful for it. But I'll try and be as succinct as possible, and in the light of what I've heard, I'll try and cut down what I have to say tomorrow as well. But with your permission, I'll go straight into ground one, the reason I deal with it in the order that the judge dealt with it in is because it is a really critical ground. Because if there is no agency, then my lord Sir Peter Gross is absolutely right that all that is left is a counterclaim against Noor Bank. So all of the claims are successful, subject to the Islamic finance point, which was the last ground. But just putting that to one side for the moment, and that affects only two of the claimants. If I'm right on agency, if there's no agency agreement, agency relationship that can be established, then most of the banks succeed in their claims, and all of the claims succeed, subject to those 2 points. So it is critical.
Will it be open to the court to make a partial determination, for example, to dismiss the appeal in part but allow it in part?
Yes. I would suggest you'd have to do that. Yeah, you have to do that, because although the banks are represented by the same lawyers, they are distinct individual entities, and so you've got what is it, six banks, sorry, saying we have a very valuable claim against these people for X amount, and there's no defence to it. And if I'm right on agency, that is the outcome, and therefore those banks are entitled to their judgment. And you would have to find one of two things to get to the point where you nevertheless made them go through a trial. You'd either have to find the judge got it wrong on the issue of agency, or alternatively, you would have to find he was wrong to go on and consider agency, given there are these other factual debates, and that was a matter of his discretion. But if as I suggest, the agency issue is just dead clear, then it's impossible to criticise the judge for deciding that. And so
what we're talking about is the residual issue not covered by the agency point.
The residual issue of the Islamic finance aspect. Yeah. Yes, of course, you could do that. You could say that, but again, that's split between banks, because it's only two of the banks that are concerned with the Islamic finance aspect. So you would be saying, and you can see how that would be a very significant case management consequence. You'd have an argument about what is now only one of the three original allegations on Islamic banking. You'd have an argument about standard number 30 and whether or not, as a result of the way the financing was organised, it breached that standard, and whether or not, if it did so, that gets rid of the whole of the financing, it voids the contract, as has been asserted. And if it does, what that affects, does it mean they get to keep all the money? Obviously not. But I'll deal with the standard 30 and show you why it just doesn't stack. It doesn't make any sense.
But on the question of agency,
yes,
isn't that also what been saying as factual base? Factual base question of agency?
It could be. But what you need first is a case. And so the first point on agency is there is no case. There is actually no case. There's no pleaded case. And what is being asserted in oral argument doesn't get you to agency. So when we deal with the agent, I will deal with it. You've heard the background facts, and where does agency go? It goes to whether or not, if these two statements were made, one of them, there's no relevant dispute about it, but the question is whether they were made on behalf of the other banks in the syndicate. So this is the 16th of December meeting, you'll recall. It's the Palm meeting. It's 11 days before any facility agreements are signed. And there are two statements that are alleged. The first is that Noor Bank will not participate in the intended syndicate unless it receives a separate security over some other assets. All right, that's a demand being made by and for the benefit of Noor Bank. So what's being said is that the syndicate, or the proposed syndicate members, somehow authorised Noor Bank to make that demand on their behalf. But it's not making it on their behalf, it's making it on its own behalf. It's saying, I want additional security. It's like any bank in the syndicate coming in and saying, these are the terms on which I will participate in the syndicate. The other potential syndicate members aren't responsible for the demands made by a participant. It doesn't make any sense. And then the other aspect of it is you've got this allegation that Noor Bank is saying, we, Noor Bank, will give you more finance. We'll give you another 100 million dirhams in working capital. And so again, you have to have an argument that the rest of the banks have said, you, Noor Bank, on our behalf, will make a promise on your behalf, something that you will do. It's logically incoherent, we say. So as you've picked up, the question of whether that second statement, the alleged promise and the implied representations were made, that's ground 6. That was the ground where there is factual dispute. Now, I say it is clear enough at this stage of proceedings for you to make a decision, and that's what the judge did. But there are a lot of stages that have to be overcome by my learned friend before you get any relevance for that factual dispute. So that's why I'm taking it in the order that I do. So
there are really 3 different things, aren't there, or potentially different. One is the position on claimants 1 to 6. And that's your point about whether there is a real prospect. I'm not talking about burden of proof. Real prospect of Noor being an agent for the other banks.
Yes.
The second question is ground 6, where there is this factual issue about which Mr. Fraser has covered, and the third is the Sharia issue.
Yes and no, in that ground 6 doesn't get Mr. Fraser home. It doesn't get him to the point where you
ground
have
6 could get him home against Noor, but not against everyone else.
Well, no, because he'd have to succeed. Ground 6 is about whether or not the alleged promise of working capital was made. The words were said.
I'm putting it badly, forgive me. Mr. Fraser could succeed on showing, arguably, that the words were said, but you could succeed in saying there's no arguable case, nor was acting as agent for the other banks in saying that.
Yes, correct. But the point I'm making is that there are other things that the judge found against the defendants in relation to, even if the words were said, they were not actionable. Because the way that it is said that the words become actionable is either A, by way of an implied representation, and your lordships were absolutely right, that resolves into a claim in fraud, and I'll show you that, which is not advanced. So they are prevented from running that case because they can't go that far. So that's one way in which it's said to impact the parties, and the other way is as a contractual promise, and then you have to deal with the question of whether or not the terms of that were sufficiently certain to give rise to an enforceable contract. Is it right that if a bank says in a meeting, we will give you 100 million dirhams in working capital, that is a deal that is contractually legally binding in an oral statement? And the judge's conclusion was it's not, because you haven't got everything that you need in relation to that. But the other aspect of it is that the agency case doesn't just determine the claim by the first to sixth claimants. It also determines, at least on this basis, for the purposes of the first 6 grounds, the claim by the other claimants as well, because there's a no set-off clause. And so if the contracts can't be rescinded or terminated, then you've got a debt which arises, no set-off, and therefore just a counterclaim. So we would still be successful, subject to the Sharia point, on the whole of the claim. All of the claimants would be successful on all of the claim. But there would just simply be now a new counterclaim, a freestanding counterclaim, being brought by the defendants to the effect that there was a tort of intimidation, or alternatively there's a contractual promise which was breached. So it doesn't affect the claims unless they win on agency. Does that answer the question of how it all fits together?
Possibly.
I can try to elucidate a little further.
Carry on. Carry on. We'll keep that in mind.
Thank you. All right. So I was making the point just at the outset that if one looks at the 2 statements that are alleged to have been made, those are either demands being made by Noor for things that Noor was requiring, or alternatively promises, statements about Noor's capacity, Noor's intention, or promises of Noor's intention to lend. And so that would have, the case would have to be, because of course we're at the stage before there's a syndicate, the case would have to be that each of the lending banks, that's Emirates Bank, Al Khaliji France, HSBC, United Arab Bank, National Bank of Fujairah, and the Commercial Bank of Dubai, all of them would have had to give some sort of authorization to Noor Bank to make those sorts of statements on behalf of the syndicate. It's a very strange allegation to make. As a matter of common sense, we'd say it's obviously up to each lender to determine the conditions on which it's willing to lend. And just dealing with the OBN security, because that's where that goes. It is a problematic feature of the defendant's case that on their own evidence, their position is that the discussions about OBN security were kept away from the other banks. Mr. Al-Mahari says it became apparent to him that only Noor knew about the discussions about OBN security. That's Mr. Al-Mahari's witness statement, paragraph 54. And the reference is at page D, tab 6, page 1185. So on his own evidence, this is a secret deal. The OBN security, at least, is a secret deal that's being done between Noor and the group. Now, in submissions, my learned friend rather expanded a little bit and made the rather loose submission that the OBN security was demanded for the whole of the syndicate. Now, there are three substantial problems with that. The first is that that is not his case. His pleaded case is at page C39, paragraph 62A. And the allegation there is that the demand is on behalf, is for OBN, for Noor Bank, the eighth claimant. So C39, paragraph 62A. If the chairman did not agree to security in respect of OBN energy being provided in favour of the eighth claimant. So that's the case, and yet it changes. The second problem with his changing case is that it actually reflects an inconsistency in Mr. Al-Mahari's evidence itself, which you find at page D, tab 6. Page 1181, we start there. You see at paragraph 40, he says, it is true that Noor Bank stated that they wanted to reduce their exposure and stated that they did not want to proceed with the syndication at the level proposed without keeping Mujmat, that's the camp, to themselves as security for that exposure. I would, however, note that this is not a point I remember Noor Bank bringing up. It's also true that they said they would only proceed with the syndication if they were provided security over OBN. Now, on the next page, Mr. Al-Mahari says something different, paragraph 42. Where he says that the requirement was that the OBN security was provided to the syndicate, but then at 45 he goes back again, where he says that the security has to be provided to Noor Bank. But then you see at 54, the passage I was referring to you earlier, this is on page 1185, the last sentence, he's talking about a meeting much later in December 2019. And he says, it became apparent, last sentence, it became apparent that Noor Bank had not told the other banks about OBN. So my learned friend makes the submission to you today that the OBN security was being demanded for the whole of the security, for the whole of the syndicate. It's not his pleaded case. It's inconsistent with his evidence. But not only that, it leads to a totally incoherent case. What is the importance of the OBN security? It's said to establish a case in duress or intimidation. That requires, my learned friend accepts, an illegitimate threat. That is a threat of illegal action. Therefore, he has to show that the threat, which is not to participate in the security, would be a breach of contract or breach of some legal duty. Where does he get that? He gets that from the IMLA letter. So he says there's a contractual obligation on Noor Bank to participate in the syndicate, but they're threatening to break that contractual obligation. But that contractual obligation is only on Noor. So if it's the whole of the syndicate that is demanding security, so what? The other syndicate members don't have any kind of legal obligation to lend. Parties who are considering, banks who are considering joining a syndicate can obviously make demands about the security that they want to. So this shows why the agency point just can't work in relation to the OBN security argument and all of the consequences with duress. I'll come on to the other aspect in a moment. But in relation to the OBN security, he has to say both that this is being made on behalf of the whole of the syndicate, and also that that is somehow illegitimate. Whereas his only reason for saying it's illegitimate is because Noor Bank is obliged to participate in the syndicate. So if it's being made on behalf of the whole of the syndicate, there's no case for it being an illegitimate threat not to carry on with the syndication. That's why it leads to a completely incoherent. But what it shows is what you have is a shifting of ground to try to deal with the discrete problems that the defence faces in this case, without any regard for the bigger picture of how it all fits together. And when one takes a step back, one sees that it is incoherent. My lords, I'm going to carry on with that introduction until I'm told to stop because of the amount of time that we have. There is, in a sense, an easy answer on this ground, because the defendants, we say, have not challenged the primary basis on which the judge rejected the case. The judge's conclusion was that the allegation of agency was just a bare plea, and therefore that did not get over the line. And a bare plea of agency is a mixed question of fact and law, and you have to plead the primary facts from which you say the agency is derived. And that's a principle that's been applied in this court on a number of occasions, amongst them a case called First Round, which we refer to in our skeleton. It's at F1 30, page 1274, paragraph 26. I won't take you to it and any of these things unless you'd like to see them, simply to move forward with the time. But that was specifically about agency. It's not enough to say. Yes. Is
paragraph 55, is that right? That's
defence and counterclaim, paragraph 55, correct. So if we look at that, we see at page C, bundle C. Just dealing with this one query, just to show you where it is. It's page 37, C37.
C37.
Paragraph 55. This is all that is pleaded. Everything is then referred back to this. At all times during the OBN meeting, the 8th claimant was acting for itself and as agent for the 1st to 7th defendants. And then there's the vicarious liability argument, which has gone. So it is a single sentence, a bare pleading of agency, which has not been particularized, and the underlying facts are simply not asserted. So that was the primary basis on which the judge rejected this aspect of the defence. And you see that in the court judgment, at page bundle B, page 11, paragraph 15.
What was the page number? Give me the master number. It's easier for me.
B11.
B11.
Okay. And remarkably, there's a difference between the parties about what the judge was actually deciding here. And there's been a couple of occasions, and I'll pick them up as we go, where some of what the judge said and found has simply been mischaracterized, particularly when it comes to the Sharia points. But I'll come back to that. In this regard, you can see at paragraph 15, the judge says 4 lines down, there's simply no basis for the allegation which is made by the defendants. This is as to agency. No facts are pleaded of any actual authority to act as agent, and no holding out of any kind by the other claimants is pleaded, which could give rise to any ostensible authority. And then says the bare assertion at paragraph 55 is unsupportable. Talks in general terms about the principles, and at paragraph 16 goes on to deal with some of the submissions made by the defendants about how agency can arise. And then at the end of paragraph 16, over the page, the last sentence, none of this assists the defendants in this case because there is no pleaded factual basis for any allegation of actual usual or ostensible authority. So the judge's conclusion was that it just failed at the outset, and there is no appeal against that. We made the point in our responsive skeleton argument for the application for permission that there was no challenge to that, and no attempt has been made to amend the pleadings, to even today, to tell you what the pleading actually would be. All my learned friend finds to say in his skeleton argument is he says he feels able to say that the judge did not dismiss the claim on that basis. It's right that the judge went on to consider the various unpleaded ways in which the defendants tried to put their case, both in the skeleton argument and orally below. The primary basis for his conclusion was that there just were no pleaded facts which could support it. And he was emphatic about that in his refusal of permission to appeal, which you find at page 39, and it's paragraph 2, B39. There was no pleaded factual basis for the allegation of agency, and no actual basis for it in contract, in conduct, or in the IMLA letter. And even now, there is no positive case. The defendants do not identify the facts from which they ask the court to infer that NOR was authorised by all the other banks to make these demands or to make these promises. And you need to assert a positive case. This is not an investigatory process where you say, it's in effect, my learned friend says, well, it might have been acting for the syndicate. And we want to rifle through the documents to see if we can find any fragments that indicate that. You have to assert your case and then seek documentation or produce evidence which is relevant to those factual assertions. And the closest that the defendants come to actually asserting a case is in their first subground of appeal. And in effect, what they say is that this is a case of implied actual authority. So in effect, what they're saying is that the claimants, they say, conferred authority onto NOR Bank by permitting NOR Bank to, quote, spearhead negotiations with the group. Now, you don't see that anywhere in the pleadings. No particular facts are identified in relation to that. But in their footnote, in their skeleton argument, it takes you back to their underlying skeleton argument, which identifies 3 particular facts. But it sounds like what they're saying is it's about NOR Bank spearheading, as they put it, the negotiations with the group. So that ultimately is all about NOR Bank's role in the syndication as the arranging bank. And so that is the nature of the case, it seems, which is that because it took that role as arranging bank, it was somehow authorized to make promises on behalf of the syndicate, or alternatively make demands for itself. And that's the nature of implied authority, is that it is either actual or apparent authority that flows from a party's appointment as a particular kind of agent. So you get appointed to a particular position, and that position carries with it implied authority, whether actual or apparent. But that doesn't come with being appointed by a proposed borrower as an arranging bank. The arranging bank is appointed by the borrower to go into the market and to find banks to participate in a syndicate. That there's no specific fact that is alleged beyond its role in undertaking that role. And so in that role, of course, the arranging bank communicates and passes communications between the proposed lenders on the one hand and the borrowers on the other. But that doesn't make it an agent for those proposed lenders. And it obviously, we would suggest, doesn't make it an agent of those lenders for the purposes of making demands or of making its own promises about money that it will put in. So its role is in part to communicate individual banks' demands to the borrower.
If I understood Mr. Fraser correctly, he said the role could shift over time.
Yes.
Therefore, although you may be right to say that the arranging bank begins by acting for the borrower, you couldn't, at least without a factual inquiry, necessarily conclude that it was confined to that role. I think I'm summarizing what was said earlier.
Yes.
How do you deal with that?
Well, there's a number of problems there, because the authorities that he showed you, none of them begin to suggest that an arranging bank becomes an agent for the lenders. You were shown passages which suggested that in a narrow set of circumstances, the arranging bank might owe a duty of care to a lender. That's it. That's all you were shown. And that in itself is a highly controversial suggestion. And you'll see that there in the authorities there are differing views about whether that could ever really arise. But beyond that, if you're just asking the question, could an arranging bank be in general terms an agent of an arranging bank, simply, sorry, of a proposed lender, simply by reason of its role, the answer is there's no support for that whatsoever. It doesn't flow from the role. So take a situation. If, for example, one of the banks had committed contractually to enter into this syndicate, and so it was obliged to do that, and then the bank said to the arranging bank, I am not going to participate now. I know it's a breach of contract, but I'm not going to participate unless I get something more. Then you've got some sort of duress argument, which could then be passed on to the borrower, couldn't it? So you could have a situation where there's express authorization from a lender to say, you take this piece of information, you can take this demand from me and pass it on to the lender. But that is a specific and discrete factual allegation that would need to be made. And it's inconsistent with the case that's being run, because there's no allegation that any particular lender is saying, other than Noor, is saying we make these promises, we make these demands. And so, yes, it's right that the role of the arranging bank can change over the course of the arrangement, but the cutoff, one has to recall as well, in that authority that you were shown, is the point at which you've got commitment from the banks. And of course, at this stage, the allegation is that there is an argument about the terms on which Noor Bank will participate in the syndicate. So in those circumstances, it just is logically incoherent to say that Noor Bank is saying, on behalf of the syndicate, I, Noor Bank, make these promises. And there's no factual assertion, there's no allegation, which goes.
One thing is, the first ground is not pleaded properly.
Well, it's not just that. It goes beyond that. That's the first point.
Yeah, not pleaded. There's no evidence, nothing to support. Well, the word, nothing in the affidavit to say how the Noor is led to be shown that there are or rather Noor is the agent for all the banks. There is no evidence except for the simple allegation. That's what you're saying. But Mr. Justice Peter Gross, my brother, pointed out that Mr. It's like to show that given the chance, he will prove that there are evidence to show that Noor is. So it goes back to the question of factual base. You know, what they're saying is, give me an opportunity to prove my case. That's all they're saying.
But what is the case? Because it's not enough. The point about the pleading point is it's not enough just to say you were an agent, full stop. That is insufficient, because that is a conclusion based on facts and law. So what you have to do is identify your facts and then say, at trial, I will prove those facts. Now, in this case, the only facts that are alleged is that Noor Bank was acting as the arranging bank. Now, the authorities show that at least for the first stage, ordinarily, the arranging bank is going to be acting as the agent of the borrower. And that flows from the nature of the role, because you have the arranging bank agrees a term sheet with the borrower, and then the term sheet sets the terms on which the lending is offered to the market. And then on behalf of the borrower, the arranging bank then goes out into the market and offers around the term sheet. And so then, of course, it communicates the negotiations between the parties in relation to that. But at no stage does the arranging bank become the agent of the lenders. It doesn't suddenly switch at any point. And the authority that you were shown indicates that during the course of that, there may be times when the arranging bank owes duties to the lenders, possibly. So that's the rather controversial area. But the question is then, if they're being asked to do, for example, due diligence, or if they should have done due diligence, and that is being presented to the lenders, and they rely on it, then one can see that there might be some sort of duty of care arising in negligence. But that is a totally distinct conversation than who's, are they actually acting at any point as an agent for the banks?
I'm very conscious of the time, and
Yes.
certainly for my two colleagues. But just to be clear in my own mind, your point isn't simply a pleading point, if I've understood it correctly. It's that no basis has been identified for the agency claim that is arguable.
Yes.
But
Correct.
if it's just a pleading point, it can be amended.
Yes. Correct.
Thank you.
No, well, yes. I mean, but I think it's easy to dismiss pleading points as being highly technical.
Yes.
But the point of the pleading is so that the party can actually be held up to say, look, what is your case? What actually is it? Where does this agency relationship come from? And if you can't commit that to writing, then you are not, there's no point in having a trial. There's nothing to have a trial about.
Thank you.
And so when it comes to the second stage, though, is there an arguable basis that has been suggested in all of the oral submission, in all of the many, many pages of writing that we've had? There are two fundamental problems. The first is that ultimately it is said that it stems from this role as arranging bank. That does not get you to a general relationship of agency. But the second is you have to look at what is being alleged was said and say, does that fit within that agency relationship? Is that an incident of that relationship? And obviously it is not, because the closest my learned friend gets is to that second stage of the arrangement of the syndicate, where everybody's committed and it's a question of negotiating documentation. So the commercial terms are set. In that context, if the arranger then says, well, actually, I might well participate in this syndicate, but here are my terms, that's got absolutely nothing to do with its role as arranging bank. It's a separate and distinct capacity. It's not unusual. Sorry.
I'm sure if you look hard enough, there'll be some textbook on banking which will support your statement that an arranging bank is not an agent for the other banks.
There is.
It will help us in preparing our ground.
So my learned friend took you to a passage of a book called McKnight. There's another book called McKnight, and we've shown you the passages from that. I'm not sure. I haven't yet figured out whether it's the same McKnight, but we have shown you the textbook commentary on this, and explains why it is that arranging banks don't owe fiduciary duties to proposed syndicate members. I mean, and then there's another logical problem, isn't there? Because there isn't a syndicate yet. There's no syndicate until they sign up. So this is 11 days before there's a syndicate, and yet, so who are they making these representations for? What if one of the banks dropped out and another one came in? It doesn't actually work on either level. I'm also conscious of the time, but if you can give me another 15 minutes, it may be that I can make some progress. But I don't want to press if the court wants to stop.
Robert, Mr. Justice French, would you agree to allow him to complete on this subject of agency, and then we close it tonight on agency?
I'm a bit reluctant, Chief Justice, to. It's been a fairly long session. I'd like to maintain concentration to ensure that, it's now 9:15 Perth time. In the
well, if that's the case, then Mr. Montagus, can you continue tomorrow?
Of course, of course.
Fresh.
You can have me.
More fresh.
Can I just ask my two colleagues, are we staying online when everyone else has gone? Or
yes, I would like to. If you don't mind, no, we can go.
Subject to the time in Perth.
Yeah, that's okay. Yep, okay.
Just 10 minutes. 10 minutes. 10 minutes.
Okay.
Then
We stay on this
can,
link, do we?
Can go off. So to the council, Mr. Fraser and Mr. Montague Smith, thank you very much.